for inclusion. Deeply obliged, sir.
Group 2 application for inclusion.
My lord, may I be permitted to mention, my lord, I mentioned, and your lordships were pleased to direct me to come after some time, after 1 week, for my lord hearing inclusion. Because my lord, without having the requisite qualification, without publishing the panel, the incumbent was appointed. I am deeply obliged to you.
My lord, I'm praying for leave to file a mandamus application, my lord, without the certified copy, on the basis of server copy, my lord.
When order was passed,
The order was passed on 3rd January, my lord. I applied for 8th January, certified copy. Grateful, my lord.
annex the copy of the application for
Yes, my
certificate.
lord, I annexed it. Grateful.
Your Lordship, on the earlier occasion, your Lordship directed us to submit the written notes of argument.
May I have your lordship kind leave to mention, lordship, one appeal. It was taken up by your lordship 1 week back. Due to there was a report of the stamp reporter that 13 days delay was there. So no section 5 was there. Though contempt is pending, lordship, next Tuesday the contempt will be taking up. It is running in the list, but it is item number 56 and lordship is taking up 4 matters below. So
Whatever. So you,
can it be taken up on Monday,
that
lordship?
was called, you did not appear.
No. It was not called, lordship.
Okay.
Grateful, lordship.
Only thing is, we'll take up one day.
Monday, lordship, Monday. Grateful.
Take up one day, just keep it.
With the leave of my Lord Justice Bishash, may I be permitted to mention a matter before my Lord Justice stand in?
I will sit singly one day, don't worry. It will be appearing in the list.
My Lord, it's a judgment that we have.
I know.
I'm grateful to
May I
my
hand over the seat, lordship?
Yes.
Do you mention item number 1?
Yes, my lord, I am for the petitioner. This is restoration application, my lord. It is assigned matter. The matter was dismissed. This is Central Administrative Tribunal against the Central Administrative Tribunal. The petitioner has come before this honorable court, and by your lordship's order on 11/7/2024, that matter was dismissed.
List it. The matter has come up.
My lord,
assignment.
just I have received the copy of application.
Let the application be listed in the next week. The copy of
It will be. Yeah, picture.
this relates to what?
My lord, I am for the petitioner, my lord.
Group 2 or what?
Group 2.
My lord,
The group 2 matter?
yes, your lordship, group.
The same order next week.
Item number 3.
Yes, ma'am.
একটা সিট দিন।
না, আরেকজন আছে।
মানে একদম মিনিমাম দেখো in the
Well, this is suo motu content issued by the Supreme Court, my lord. Here, my lord, last occasion, your lordship was pleased to direct the state authorities to bring on record.
photo contempt.
Yes, my lord.
PIL.
My lord, last occasion, your lordship.
Not a contempt, madam.
Yes, my
It's
lord.
a PIL.
I'm praying for your lordship.
Yes.
Last occasion, your lordship was pleased to direct me to bring on record, my lord.
তো পিল হেডিং এ কোথায় কত নম্বর আইটেম four is আচ্ছা where is Mr. Advocate General?
My lord, he is engaged before court number 26 in an appeal. If your lordship sees the last order of your lordship,
Last order, he was directed to look into the matter and take an appropriate instruction. What is
yes, my lord. Last occasion, my lord, orally your
What
lordships direct us to
Who is
bring
for
on
the
record.
petitioner?
Yes.
Who is for the petitioner?
Yes.
It's a suo motu.
This is suo motu, my lord.
Who is for the state now?
My lord, I am appearing for the state.
Why, what is the instruction?
My lord, yes. Last occasion, your lordship was pleased to direct us to bring on record how many matters are pending in regard to the wetland in West Bengal. There are two wetland. One is East Kolkata wetland and another is Sundarban area, my lord. Now, my lord, I have instruction in regard to East Kolkata, my lord.
Why not Sundarban?
My lord, I asked for it for the concerned department because this department.
File a report.
Yes.
What is the status of those matters?
My lord, at page 5, those are, my lord, pending cases. Pending cases. Those all the matters are at 60 matters. Those are pending.
Pending as a PIL?
My lord, some of them are public interest litigation and some of them are, my lord, writ petition. My lord, kindly see the number.
I have seen 2015
Yes, my lord.
onward.
Yes, my lord. 2015 onwards, my lord, few are public interest litigation.
What are the orders?
Where
passed?
there is mentioned P, my lord, under bracket WPAP, those are public interest litigation means, my lord, four,
27.
five are public interest litigation among
Sundarban?
60.
Pursuant to the direction dated 9 Call the next.
Application item number 61.
I am appearing for the respondent college.
Yes, what is this? Why there is a discussion?
Item number 5,
What?
it is fixed for clarification.
But I am told this is not for clarification. Your lordships heard us at length.
CAB,
Written submissions. As your lordships.
Written submission somebody filed today in your matter?
no.
Written
have-
submissions are here.
Yes, Lord, we have a copy. But I have submitted.
Already submitted.
Already submitted.
What is
If your lordship wants that, I will make it.
what is this matter?
Well, this is in regard to the DLED qualified candidates who opted for B.Ed and then DLED.
It was hard long back. If your lordship wants to get us alert,
Yes, refreshing,
then we can do.
do it.
That's their appeal.
Well, then give us another day, next week, your lordships.
Why?
I have forgotten everything, frankly. This was harder.
That's not very difficult one. Let him come refreshing himself.
I have also forgotten, frankly. I prepared the notes also, submitted.
I think there was something which happened. It escaped from the notice, so we wanted it to be.
Yes, because of the long back hearing, lordship might have missed it.
Keep it on Monday, your lordships, or Tuesday, your lordships. Tuesday, your lordships.
Tuesday, Wednesday,
Tuesday is which date?
Wednesday, not Tuesday.
Oh, is there-
No. Tuesday is 28.
The 20th, not 29th. 20th, Supreme Court is asking you.
Then come on 5th.
February, very well. But after mid-February, after 13th of February.
Why?
61.
When it starts?
But it starts from 31st. The first it will be the terminate on 13th,
Want you to come on 27th?
27th of January.
Okay.
So that is not the school scam matter is because the Supreme Court fixed. No, let it be not in the month of February, but 13th or 14th February, subject to milder's convenience.
13th? Hey,
That's it.
13th February.
Item number 7, my lord, is that I have filed an urgent application day before yesterday. My lord, the EPFO authority has fixed 31st January is the last date, so that the employer can. My lord, my learned friend is appearing on behalf of the NTPC. My lord, EPFO at a date fixed করে 31st January. Then my lord, the account of signature is not being forwarded to the portal of the EPFO by the NTPC. That is why, my lord, I filed this application so that, my lord, appropriate order may be passed, my lord.
What is the difficulty?
NTPC. NTPC is not forwarding the application. Joint option form, we have submitted, the petitioner submitted, but they refused to. We have served copy, my lord. That is the urgency.
So let that application is appearing or not?
Not appearing, you have filed it before yesterday.
Number,
My lord.
come on 24th.
24.
Yes.
Grateful to lordship.
Instruction, you know.
Grateful to lordship.
Next.
24. 10, 14.
ঠিক আছে, ঠিক আছে।
ঠিক আছে? 10, 14.
Item number 61.
61, my lord, I am appearing for the respondent.
My lord, in this matter, Mrs. Usha Maiti is appearing for the appellant. My lord, due to her personal inconvenience, she could not come today. My lord, kindly keep it on Friday. My lord.
No Friday.
No, Friday.
Friday হবে না। Monday.
Friday or
Then on Monday, my lord, then on Monday.
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 Sir, 29th করে নিন না। 29th.
কি
My
বল?
lord, if possible, as per your lordship's convenience, my lord, 29th, my lord. Then, my lord,
Make it Monday.
এটা 24 বলে তো না?
Lordship, with your Lordship's kind leave, I am appearing as appellant in person through virtual mode, Lordship. I want to withdraw the appeal, Lordship. I don't want to press with the appeal. Item number 62, Lordship.
Who are you?
I am the appellant in person, Romit Dotto, Lordship. I am the appellant in person, Lordship. In that matter, I don't want to proceed with the appeal, Lordship, with liberty to approach the university authority for refund of my fees.
That is not the case here, my
Sir,
lord.
sir, the difficulty is that you have filed through the lawyer. Have you
Yes,
revoked the
Lordship.
power? Have you revoked the power of a lawyer?
Lordship, I have obtained no objection from the learned lawyer who had filed the appeal, Lordship. That is with me, Lordship.
He does not want to proceed. How can
Yes,
you stand
yes.
in the way?
No.
That's all.
So far as the fees he wants to, lordship,
We are
return
not
back.
going anywhere.
That is not the
That is
subject
his,
matter.
his right. If you want to go, he can go.
That is
Can you prevent him from going anywhere?
no.
So
That's I only want to, lordship, submit that. That
the
is not the
appellant in person appears and submits that though the mandamus appeal was filed through
বললো
yes.
63.
grateful, Lordship, obliged.
63, my lord, I am appearing for the University Grant Commission. On the last occasion, my lord, directed the university to file an affidavit. That has not been done.
My lord, I am appearing on behalf of college, my lord.
This is the last order.
There is the affidavit.
My lord, just 5 minutes. My senior is on his way.
This is the order, my lord, passed by my.
So pass over. Short.
Thank you.
No, right. Your losses has heard at length asked, and my junior also
So,
submitted.
look at the plight of a
That's I
junior.
got your losses.
So,
So then your losses make it Monday do it. No.
My lord, if my lord,
What possible is very
my lord, if
difficult.
not,
Chief
my lord,
Justice said.
today not here, my lord, then my lord, I have some difficulties, my lord. I will go for eye treatment, my lord. On 11th, I will come, my lord.
My lord,
11th, my lord.
pass over, wait for it.
Call it. But after before the courtroom number one item, then I will come.
If today I will, it will. My lord, my senior.
Now he has come. So now he has.
kindly see the last order, my. Kindly see the last order passed by my lord.
Last order.
No any affidavit has been filed.
Lord, when
And the reason is this, my lord, University Grant Commission already taken decision.
Well, that's is not covered in our case.
yes,
My learned friend should say it factually. Because that's a
Kindly
different
say.
session.
Have you filed your supplementary?
No, my lord, may I just indicate one thing? On the last occasion, when time was hot on ground of Mr. Gupta, my lord, I had indicated that possibly, my lord, an affidavit will not be required. Why? Because my lord had indicated I am to take instructions whether or not in a different matter for a different petition, a person who was availing benefits of similar direction but not identical was granted accord by the UGC or not. My lord, may I just hand over to documents I handed over on the previous occasion as well?
I have handed over the copy of the
Well, I am-
order passed by the secretary, my lord, as per direction of the court.
Just kindly दिए देबेन।
Last two paragraphs, kindly see.
I am relying on the entire thing. I'm not saying that the what I had made submissions on the previous day.
Previous day,
Correct.
false statement made before my lord. False statement.
Mr. Gupta, you are a most senior advocate.
Sorry, my lord.
I think more than 30 years
Sorry,
of
sorry,
standing at the bar. His turn is there. Let him argue. Your turn will come.
Sorry, sorry, my lord.
On the occasion that the question had fallen for consideration, and my lords had asked me the question whether or not the degree was answered in the positive.
What you wanted to rely
Yes, my
upon.
lord. Well,
What
my
is
lord
this?
had put a question to me.
So this is also given. So why double?
Oh, I'm sorry.
Yes.
My lord had put a question to me whether or not the degree to one Mr. Shumanto Majumdar, who was a writ petitioner, a different writ petition, was accorded or not. I had off my cuff said that, my lord, it is accorded, but kindly allows me to take instructions and come back. My lord had recorded in my lord's order that I submitted, that it was accorded. However, my lord felt the need to take instructions with respect to the same and come back. My lord, this is the recent order of the University Grants Commission. Now, my lord, may I take exception to this and submit why this order will possibly not apply to the writ petition in the present case. My lord, for the purposes of that, my lord, may I just, I had also handed over an order dated 22nd of September 2023, passed by a coordinate bench of this honorable. This, my lord, is the order.
In Sumanta Majumdar.
Yes, my lord. This, my lord, is the order passed in with respect to the order that has been given by the University Grants Commission, by version of the reasoned order. But I will kindly take, my lord had two primary questions of me. A, will the DEC circulars apply when the UGC has taken a stance that Professor Yashpal's judgment completely obliterates the concept of franchising of study centers of distance mode? My submission to this was twofold. A, I am a state university. My statute allows me to run in a distance mode. B, I am not franchising study centers. The study centers that I am operating outside my jurisdiction in furtherance of the powers granted to me by my act are completely under my control and also are within the guidelines as prescribed by the Distance Education Council from time to time. B, the time period, this, my lord, is annexed in my affidavit. I have put all these on affidavit. My lord had also put a question. My lords had already also put a question to me whether or not there was any approval granted with respect to the petitioner's, now the appellant, the course that he had undertaken before my university. I have, my lord, shown from the record that a post facto grant or approval was given to our university in offering the degree that the petitioners has undertaken. As such, this post facto grant squarely covers the duration within which the petitioner obtained its degree. Now, my lord, why I asked my lords to kindly take this order was, if I make my lords kindly seek my lord's attention to page 2 of this order. Here, my lord, the facts and circumstances were completely different. In this situation, the degree had merely commenced when the post facto grant was given. However, the degree was completed in a period that was a gray area, in the sense that, my lord, when the degree in this writ petition had completed, at that point in time, intimation was given by the Distance Education Council that I shall personally come and inspect and ascertain whether the situation that you have taken for the purposes of opening study centers are within the prescribed norms or not. The Distance Education Council came and granted approval. The degree that was obtained here was in the interregnum period. That is why, my lord, in the order, in the order or the ordering portion of this judgment that I've handed over, the Honorable Division Bench at that point, presiding over this matter, my lord, directed the University Grants Commission to take a call whether or not the degree is valid or not. My lord, may I kindly come to answer one question that my lord had posed, which is possibly answered in the affirmative, in my favor and possibly the writ petitioner's favor or the writ appellant's favor in this situation. My lord, kindly takes page 2 of the order, my lord. The primary concern that my lords had opined was also the primary concern here, and possibly that is decided, my lord, subject to correction, of course. The primary concern is the approval and recognition of the degree under the distance education course. My lord, I'm reading paragraph 6.
Yeah, no, I'm also reading that.
Yes, ma'am. After the decision of the Honorable Supreme Court and Professor Yashpal, State and others, reported at so-and-so. However, it appears that the Distance Education Council, being faced with the dilemma, particularly in respect of the courses that were pending continued after the judgment of Professor Yaspal Supra had reviewed the situation in its meeting held on the 10th March 2010, in which item number 35 subclause 3, I have also brought those on record in my affidavit, my lord. The council has specifically dealt, the council, University Grants Council, has specifically dealt with the territorial jurisdiction in offering programs. My lord, the entire 35th, or the operative portion of the 35th committee meeting is set out here. Item, may I kindly place, my lord? I will be placing reliance on the last paragraph, but I have to place the first paragraph prior. Item number 35.3, territorial jurisdiction in offering programs to distance mode. The council in its 28th meeting held on 23rd March 2007 had decided that jurisdiction for offering programs through distance mode will be as per acts and statute of the concerned universities. May I pause here for one moment? It is not the case of the University Grants Commission that my statute does not allow me. It is the case of the University Grants Commission that whatever I have done is in teeth of the judgment passed by the Honorable Supreme Court in Yashpal. As such, whatever I have done or whatever degree I have offered is a nullity. However, this in my humble submission is not correct in terms of the what I am placing, my lord. However, in the 9th joint committee meeting of UGC, AICT and DEC, so my learned senior friend now cannot say that UGC was not a part of this. Held on 17th August 2009 regarding territorial jurisdiction for offering to distance mode, it was decided that the latest UGC modifications will prevail over all previous notification and circulars of DEC. My lord, what does this presuppose? A, the prior notifications or the grants granted by the DEC are what the UGC stand by. From here onwards, the UGC will grant for the intimations, notifications, regularizations for any university. My lord. Now, my lord, what is the academic session we are concerned with in this matter before my lords? The academic session that we are concerned with ended in 2007. So even if not even on March 2010 is taken to be sacrosanct, but the minutes on 17th August 2009 are taken to be sacrosanct, the degree obtained by the writ petitioner appellant before my lords is a valid degree. My lord, may I kindly continue? The council considered the roles and responsibility and the authority of the joint committee and decided that the joint committee cannot supersede the statutory authority of the Distance Education Council. Well, the UGC then by this agrees or admits the position that with respect to distance mode and for grant of degrees in distance mode, it was the Distance Education Council which was the statutory authority of the Distance Education Council. The council noted that distance education and online education cannot have the territorial jurisdiction. And it was decided that in case of central universities, my lord, the university before my lord is a central university. And state university, I'm sorry, my lord, it's a state university. I stand corrected. The territorial jurisdiction will be as per their acts and statutes for offering programs through distance mode. Not the remainder portion are for deemed universities and private universities. I'm not laboring into that, my lord, as of right now. May I just, yes. May I just, in light of this, just show one document from my affidavit, which will, in my understanding of the law, which is of course not as great as my friends, my learned senior friends at the bar and my lords, of course, kindly takes my lord page 28 of my affidavit. This is my lord an affidavit affirmed on 11th day of September 2024. Yes. No, the entire thing, I'll just read this. (11th September 2024. 11th day of September 2024. On affidavit, the title of the affidavit is affidavit on 17th September, my lord.
The counter affidavit of reply.
No, my lord. The affidavit on behalf of the added respondent, Madurai Kamraj University. my affidavit before my lords today. One page possibly will settle the issue. Page 28. Kindly, if my lords are pleased to take. This grant or post facto approval is issued on the 12th of September 2008. The subject, my lord, issued by IGNOU, Indira Gandhi National Open University. I'm sorry, my lord, acronyms are not to be relied upon. By the Distance Education Council, top right hand side, my lord. Subject, post facto approval to Madurai Kamaraj University, Madurai, Tamil Nadu. This is a letter issued by the director of the DEC. This has reference to your application requesting post facto recognition of Distance Education Council for programs offered through distance mode by the Directorate of Distance Education of your university. This DDE is our body that we set up for the purposes of regulating all of this so that there is no franchising of study centers. In this connection, we would like to inform you that based on the recommendation of the expert committee that visited your university, the chairman, Distance Education Council, has accorded post facto approval to your university for programs offered through distance mode with effect from 1st March 1995 to the academic year 2006-2007. I'm covered. Even if I pause here, the writ petition appellant is covered. May I say this, my lord, since I am the university, my degree offered to the writ petition appellant is covered. As per enclosed list annexure A, annexure 1, full stop. Prior to March 1995, there was no system for giving recognition to correspondence courses or distance education programs, and therefore the issue of post facto approval for such courses during that period does not arise. The certificate issued by the university stands automatically recognized if they were approved by the relevant authorities of the university. It may be noted that any degree, diploma, certificate offered through a franchising agency by the university does not have the approval of the Distance Education Council. The degree offered to the writ petition appellant is by the Directorate of Distance Education set up by my statute. It is not by a franchising agency. I will kindly, if and when my lord takes the degree, I am not limiting my lords to put into that. It is by Madurai Kamaraj University. With the bottom left-hand side of the degree says Study Center, Kolkata. Further, we would also like to inform you that it is the responsibility of the university to follow the norms prescribed by the concerned regulatory bodies or seek their recognition for professional technical programs as per the requirements. Getting approval of the concerned statutory apex body for relevant programs will be the sole responsibility of the university. The territorial jurisdiction for offering distance education would be as per the acts and statute of your university. In light of the submissions that I have made in the affidavit and this post facto grant of approval, and that the degree obtained was in the academic year 2006-07, in my understanding of the law, my lord, I do not have to labor any further before my lords. I had on the last occasion, my lords, gone on to distinguish the Yashpal judgment on two premises.
Why you have used the word study center?
My lord, the word study center is not a problem. The problem, according to the Yashpal judgment, is the franchising of a study center.
So this is what is the mean. You look at the Yashpal judgment.
Yes, my lord, I am on the Yashpal judgment.
So that it does not talk about the study center set up by the university, but a study center through franchising.
Yes.
Where is that?
My lord, I had placed reliance on paragraph 60, 61 and 62 on the last occasion to propound this proposition. With the findings was in 63 and 64, which is also my learned senior friend has quoted in his affidavit. That rightly so, my lord. Because the entire objective behind the judgment is so that A, state universities don't franchise to private bodies under the garb of obtaining funds. B, private universities do not take advantage of people in rural or non-urban areas to obtain their funds and give subpar education. This, my lord, is the intent of this judgment. My learned senior friend appearing on behalf of the University Grants Council is trying to read this into any study center.
show us the relevant portion which
Yes.
makes a distinction?
Yes. Lord, may I place from paragraph 16 that event? Dr. Dhawan has also drawn our attention of drawn the attention of the court
to certain other.
I'm sorry, to certain other provisions of the Act which have effect outside the state of Chhattisgarh and thereby give the state enactment and extraterritorial operation. Section 2F of the amended Act defines off-campus centers, which means a center of the university established by it outside the main campus, within or outside the state, operated and maintained by its constituent unit.
As it's not by.
Maintained as its constituent unit, having the university's complement of facilities, faculty, and staff. Section 2G defines offshore campus, and it means a campus of the university. It means a campus of the university established by it outside the universities.
Outside the country, offshore.
Outside the
Offshore means outside the country.
Yes, madam. Operated and maintained by its constituent unit, having the university's complement of facilities, faculty, and staff. Section 3, subclause 7 says that the object of the university shall be to establish the main campus in Chhattisgarh and to have study centers at different places in India and other countries. In view of Article 245 of subarticle 1 of the Constitution, the Parliament alone is competent to make laws for the whole or any part of the territory of India, and the legislature of a state may make laws for the whole or any part of the state. The impugned Act, which specifically makes a provision enabling the university to have an off-campus center outside the state, is clearly beyond the legislative competence of Chhattisgarh legislature. This, my lord, had the
Article 245 clause 1 talks about the extraterritorial operation of the state act.
Yes.
Central can make a law operative throughout the country, but when once it comes under the state list or 7th schedule, then extraterritorial operation is not permitted. Here the Supreme Court has said even your act may permit, but it has an extraterritorial operation. Read further there.
Yes. The amending Act of 2004 came into force on 17th March 2004. Section 4, subsection 1A, which has been inserted by this amendment, provided that a university already established in the state under the provisions of the Adhiniyam shall comply with the provisions of clauses B to E of subsection 1 of section 4 by 30th June 2004. Or else the notification issued by the government under section 1 of section 5 of the Adhiniyam shall be liable to be cancelled on the recommendations of the Regulatory Commission. These provisions related to creation of an endowment fund of rupees 2 crores and requirement of land.
These provisions related to the creation of an endowment fund of 2 crores and requirement of land.
Yes, ma'am. It appears that as many as 59 universities were denotified as they did not comply with the requirements of the aforesaid provision. Learned State Council made a statement that one more university was proposed to be denotified, but the same could not be done on account of an interim order of the court. Many private universities have filed writ petitions in this court and also in the High Court of Chhattisgarh, which were later on transferred to this court, challenging the provision of the amending act. The main challenge is regard proof of being in possession of 15 acres of land in case the main campus is proposed to be established within the municipal corporation limits of Raipur or otherwise 25 acres of land, and to the establishment of an endowment fund of rupees 2 crores. The principal ground raised by Sri Ravindra Srivastava and the other learned counsel for the universities is that The provisions are arbitrary. The conditions imposed therein are very onerous, and further, such conditions could not be imposed on already existing universities. It was also urged that the amending act has a retrospective operation. In our opinion, the challenge raised has hardly any substance. In order to establish a university, there must be adequate land on which a campus may be made and necessary infrastructural facilities provided. No university can come into existence without a proper campus, which requires land. Similarly, for those who want to establish a university, a sum of rupees 2 crores is a very small amount. It will be seen that Section 4, Subclause 1, Subclause C provides that an endowment fund shall be used as a security deposit to ensure that the university complies with the functions as per the Act. In S. Aziz Basha versus the Union of India, the history of establishment of Aligarh Muslim University has been given. Through the year 1877, the Viceroy had laid the foundation stone for the establishment of the Mohammedan Anglo-Oriental College, Aligarh, which over a period of time became a flourishing institution. Yet, when a demand was made to establish a university, the government of India made a condition that at least 30 lakhs must be collected, and thereafter the university was established by the 1920 Act. It is extremely difficult to visualize the real value of purchasing power of rupees 30 lakhs for the year 1920 at the present juncture. For those who want to establish a university, a sum of rupees 2 crores is just pittance. The fact that many private universities have challenged the provision of the amending act itself shows their intent and purpose, that they do not want to create any infrastructure, but want to have the right of conferring degrees and earn money thereby. This, Milord, is not the situation. I'm sorry, Milord, may I pause here for a second, Milord? The object behind this judgment was to deter private universities to further their financial interests and subsidize educational qualifications granted to individuals. May I, my lord, continue? However, it is not necessary to examine the challenge raised by the amending act in detail, as we have already held that section 5 and 6 are wholly ultra vires, and all notifications issued thereunder notifying the university being invalid are liable to be struck down. Shri Ravi Shankar Prasad, learned senior counsel appearing for the state of Chhattisgarh, has submitted that the impugned act was passed in order to attract private capital, and the state does not have funds to establish education universities. The policy of the government of India has undergone a change since 1991, and emphasis is on privatization. The act was enacted so that facility of higher education in the state of Chhattisgarh may be improved, and a large volume of students may get an opportunity to pursue higher studies. He has also submitted that the University Grants Commission itself has made regulations governing admission and fee in private non-aided professional institutions, which make a reference to joint venture between private trust or society and the state government. The enactment, it has been urged, is an experiment in the changing world scenario where the trend towards where the trend is towards globalization. Learned Counsel has further submitted that the amending act.
Where is the finding which says that it is only in respect of a private universities or the private institutions, not in case of a state universities expanding his the palm to another state under the distant education mode?
Then may I was placing the factual premise before the finding that was relied upon. May I just then finally come to the submissions in the findings returned in 63, 64, and 65 minutes? Possibly that will be clear.
No, it does not appear to me. I was reading it. Show us the portion. Show us.
And may I just place paragraph 64?
Yes. Placetum what?
Placetum F onwards, my lord.
Yes.
Amarendra Sharan, learned additional Solicitor General, has submitted that UGC has conducted an inquiry, and it was found that most of the universities were non-existent. But the report was not placed before this court, as complete exercise had not been done. Learned Counsel for the universities have seriously disputed this fact and have submitted that the universities are functioning. We have not gone into the question as it is purely factual. In order to protect the interests of the students who may actually be studying in the institutes established by such private universities. It is directed that the state government may take appropriate measures to have such institutes affiliated to the already existing state university in Chhattisgarh. We are issuing this direction keeping in mind the interest of the students and also section
This is Article 142.
Yes.
This is really an Article 142, taking into account the plight of those students.
Yes, ma'am.
This direction was passed.
Yes, ma'am.
But where
It is, however,
says that
the next line starts with it is, however.
please.
It is, however, made clear that the benefit of affiliation of a university shall be extended only if it fulfills the requisite norms and standards laid down for the purpose of for such purpose, and not every kind of institute. Regarding technical, medicinal, or dental colleges, etc., affiliation may be accorded if they have been established after fulfilling the prescribed criteria laid down by the AICTE, Medical Council, or of India, Dental Council of India, or any other statutory law, with their approval and sanctioned as per prescribed. The University Grants Commission says that the degree granted to by my university to the writ petitioner was not in accordance with statutory authority, or was without their approval or sanction as prescribed by law. That is why they join issues with respect to the degree granted to me. They, on the same breath, acknowledge that the Distance Education Council was the statutory authority responsible for this. The Distance Education Council grants me post facto approval for the purposes of conferring degrees from 1995 to the academic session 2006-2007.
I can understand that you have started a distance mode program where from online somebody can undergo, but you operate from your center, I mean the place where you have been established. But if you establish several centers across the country, and then in the certificate you say that it is from this study center, this is from that, what does it mean? Why the study center was mentioned in every such degree?
Because, my lord, we have according to our statute.
One university, when you are granted, it is immaterial under the distance mode that from where they are coming.
Yes, it is immaterial.
It is immaterial.
Yes.
It is a university who gives.
Yes.
Under a distance mode.
But
why you refer the study center?
Because the norms as prescribed by the Distance Education Council and the University Grounds Council for the purposes of conferring degrees takes into consideration this aspect that you must mention all of this. That is exactly why our statute had a body by the Directorate of Distance Education, who was personally present at the time of establishing of any study center to do three things. A, to ensure that all educational facilities, including the syllabus, professors, examinations, are provided by them from our central university and checked when they take these examinations. B, the infrastructure.
It is a distance mode.
It is a distance mode, Lord, because it is not within the state of Tamil Nadu that the degree is being conferred upon.
Will it not be creating a problem because the university is set up by virtue of a state act, say your case, the state of the Karnataka?
Tamil Nadu.
Tamil Nadu. There is the Tamil Nadu. Then in that event, you can span over all over the country and then set up your study centers, means appointing certain faculty members, providing the class, the infrastructure study, the facilities, and then curriculum definitely you set up.
Everything I set up. There is nothing set up
Can
by
you
the
do that?
Lord, my act provides.
Can it be done?
Lord, my act provides.
Distance means that somebody who may not study regularly or attend the classes, but have a limited way in your main center, and then appear in the main center and then give an examination. I can understand distance mode.
That's we have done, my lord.
But he says that study center has its faculty,
study center
faculty
here.
members. Study centers have all the infrastructures.
No,
means just like a regular mode of education.
well, this is not a regular formal mode of education.
This is what he says.
It's not that.
You can't say university is the best person.
their act also says.
I know that once he says, that's why I'm reacting to it.
Lord, why I say that is because I have to follow the guidelines as given to me for the purposes of a study center. I am saying in terms, I have to abide by each and every guideline given there. I am not saying it is parameteria or the same with respect to if a student would have come to my university within my state and obtained the degree. The facilities provided are not equal.
Then what is the purpose of
For the upliftment of society, my lord.
no,
at
no,
large.
what is the purpose of segregation of the powers under the 7th schedule? What is the purpose? Then every one state all over the country,
My lord, in that
another state all over the country, every state university will have I would say,
my lord, the
existence in every other state of the country.
the power established by law
That is why Article 245 is to be read. Extraterritorial operation. A state act has to apply within the territory of the state. Under the State Reorganization Act, every territorial jurisdiction of the state is defined.
Yes, my lord.
And then the federal system of the constitution is totally at stake.
Possibly, my lord, it is not.
Kindly consider, because it's the union of a state at the center.
I completely appreciate what
if
is
the
falling
state
from my
does not
lords.
have the autonomy within that territorial, then it's a farcical approach. Every state will have its existence in another state. So far as the education is concerned, it may come in a health sector as well. If the act is enacted by a particular state, which says that you can set up, then everywhere the state will come. There will be a state of Tamil Nadu hospital in Bolpur. Act says so. State of Tamil Nadu has enacted an act which says that you can have those facilities there, hospital. Our doctor employed by us, not governed by any state rules, nothing of that kind, I am doing it. Can it be done?
Not in my kindly, my lord.
Distance is different, where you can, from distant way, you can give them, but they have to go sit in your
No, the examination was held in the university.
Examination university.
but not that you are providing those facilities like that.
No, my lord. May I then one possibly, my lord, it has been a mistake on my part.
Because this has done it. The same thing. If the private universities, they were debarred from setting up this study center, then why the state? I'm really,
My lord,
they
may I
have said, UGC has said, if your act permits, you can.
to a limited extent, my lord. The limited extent is defined as given to me, my lord. I'm sorry, my lord, possibly that has come up incorrectly from my part with respect to representation, how the study center is managed and governed. My lord, may I, my lord, kindly indicate the parameter or the guidelines within which I have to function.
Because in that act of Chhattisgarh,
Yes,
which was there
There was a specific part.
in the Yashpal, the definition of the offshore campus and
Yes, my lord.
offshore center, they have been outside center, off-campus centers are defined.
Yes, my lord.
In that, it says that there must be an infrastructure in the facility and the faculty. Those were defined there. In your act, what you have said,
My lord, may I just
did they sit in the examination at Madurai?
at Madurai?
And
At Madurai. At Madurai. My lord, may I just
That is the
please-
act, what your act says.
Lord, before I just go to that, may I just say one thing? If my lords can kindly take page 41 of my affidavit, that my lords were relying on.
Yeah.
My lord, page 41 is a continuation of a letter issued by the Indira Gandhi National Open University on 4th August 2010. The annexure starts, my lord, at page 37. This entirely gives us the framework within which we have to function. May I come to the operative portion, my lord, at page 41?
Yes.
I'm sorry, my lord, it starts at page 40. I must start from page 40. Page 40, the last paragraph. The recognition of the above programs is subject to compliance of the following by the university. The university should revise and update its SLM. The university should accelerate its process of conversion of study material into SIM formats. The university should further strengthen and do so and so. For MCA, BCA, MBA, the university shall follow DEC IGNOU norms for admission and contract classes. The project component should be enhanced. The university should strengthen its project monitoring components in programs where projects are involved. Then Milord B. I'm just skipping the last one. Possibly Milord, it goes for MBA and MCA, and that is not the subject matter in dispute. The university shall note the following. The institution will offer only such programs through distance mode which are offered by the institution through regular face-to-face mode and approved by the Distance Education Council as mentioned in this letter. The institution will not offer any other programs through distance mode other than those offered by the Distance Education Council. Technical engineering programs require AICTE recognition, and other professional programs require approval from the concerned statutory council. The programs in areas of health, nursing, and dentistry are allied areas and may be offered with the approval of the statutory council and regulatory bodies wherever required. It will be the responsibility of the institution to follow the norms as prescribed by the regulatory bodies and seek their approval wherever required. The nomenclature and of the program should be strictly as prescribed by the UGC AICTE.
Paragraph 9. 9 is
the territorial jurisdiction for offering programs through distance mode will be as per the decision taken in the 35th meeting of the Distance Education Council. In its 35th meeting, the council noted that the distance education of online education cannot have the territorial jurisdiction. In case of central universities and state universities, the territorial jurisdiction will be as per their acts and statutes. This is, my lord, the reliance that I placed on, my lord, the coordinate bench's judgment. The territorial jurisdiction in case of private universities other than private institutions other than universities shall be as decided by the joint committee which had decided that the territorial jurisdiction for other institutions, both private as well as government funded, shall be the headquarters and in no case outside the state. The second a private funding issue comes up, the restriction is granted that I cannot travel beyond the state, because it is presumed that when private influence comes into funding, the control will be lost by the university. That is why the specific embargo. And that is not, in my understanding, what the Yashpal judgment propounds. The Distance Education Council prohibits franchising of study centers. Thus, your institution will not franchise any study center. This is why the rigorous control offered by us over the study center. The institution's management of the distance education program will be open for review and inspection from time to time by the DEC to provide inputs for further improvement or as deemed necessary. The academic norms of the program shall be under monitoring.
Distant education programs.
Yes, ma'am.
This is recognized, which is the statutory body to give a recognition. It's a UGC.
Distance Education Council. The Distance Education Council, as admitted by the UGC. I'm sorry, the Distance Education Council wing of the Indira Gandhi National Open University. I'm sorry.
So Indira Gandhi Open University is the apex.
Yes,
in this regard, and that whatever the conditions they would put
are final and binding.
This is what you're.
Yes, and
what is their stand in this?
Their stand is that regardless of whatever had been given to you, which has never been recalled by them till date, whatever is given to you does not hold water. You have opened a study center outside your territorial jurisdiction, you are barred by Yashpal.
So they are just banking upon the Yashpal.
Yes, one thing.
They are not disputing that the Indira Gandhi Open University.
They are not disputing that the Indira Gandhi National Open University has granted me a accord. They are not recalling any post facto approval given to me. They are not taking away my university status. They are not putting an embargo on students obtaining degrees from me. They are not saying that degrees obtained by any other time are incorrect in law. They are not taking steps against degrees offered by me, even as on date. They have not recalled any of the meetings where they were a part of, specifically the 35th committee meeting on 10th of March. If, my lord, the UGC takes a stand that they are silent about this and they are keeping at it, that means that they have admitted that A, I have not franchised my study centers, and B, whatever I am running in different parts of the country are in accordance with law. Had it been otherwise, my lord, in my humble understanding, they would have recalled all these post facto grants given to me. without the recall of all these grants given to me.
Where is your statute which?
Yes, my lord. I had handed up the statute, but I had annexed the relevant portion of the statute in my affidavit. The relevant chapter is in that I had annexed in my affidavit is at page 43. My lord had also asked me to bring on record the entirety of the statute. I had also handed copies of the same over on a few occasions back. My lord, may I please? Chapter 2032. Directorate of Distance Education. This is not the body that has been enacted by our statute for the purposes of giving all, taking care or supervising all degrees granted in the distance mode. The university shall be, I'm sorry, my lord. There shall be a Directorate of Distance Education, including open university system in the university. The directorate shall provide instruction for such courses, correspondence as are decided.
The manner in which it is found, the language does not indicate that it's a statutory language. That is why it creates a confusion.
Then, my lord, may I place from the
statute is always worded in a different way.
Yes, my lord.
Not in this. This appears to be a guideline. There appears to be some kind of a executive handbook.
Yes. Then may I then show from the statute then? May I hand it over the statute on the? It's a voluminous document.
I know that's a voluminous one.
It's a voluminous.
This is Indira Gandhi National Open University.
No, my lord, it will be about 300, 350 pages.
And,
305 pages to be precise, man.
Calcutta আরো আছে? এটা, yes. Yes, this is what.
Yes, ma'am.
You want to don't have?
May I just have the relevant portion. I should just indicate the page number and hand over back to
You know,
in the page number. I should just.
the relevant page which you are trying to do, just flag mark.
Lord will kindly excuse the language of the statute, but take into consideration the contents of the statute, where the power is granted.
But this is nothing but the law of the university. The act does not act with the provisions.
This is the act under which I am founded.
No. No, sir. That is what I am saying. The act ends. Actually, the act ends. here, then there was certain amendment which have been brought, which ends here. And then this is something else has come. Please read that. First tag mark, second tag mark, third tag mark. And then last one is yours. Look at the first. It ends with the repeal and everything. The act starts and the act ends there. And then the second tag mark, you will find certain amendments have been brought. Third tag mark, you will find laws of the university. Look at the heading. Third.
Yes, my lord.
So this is under that chapter. Is it an executory one? What? Power to make the laws of the university? What? Everything has to be considered. To us from the parent section. That's why I say the wording which is used does not appear to have been used in the legislative enactment. Never used. If I say within the part of the statute, then it will be a wrong judgment.
Yeah, may I come back on this limited point?
Well, you have read it. Place a document without reading yourself.
I was aware of this document.
Yeah, I have shown you where the section, the statute ends. The statute ends normally on the repeal and saving clause. And thereafter, maximum removal of doubts.
Before is not a part of this.
That is the section 57. These are all clarificatory or executory instructions.
Yes,
That what in order to implement the provisions of that, what are required by the authority to do it. Then there is another, whether that act permits any kind of this handbook or the instructions to be issued. This is one. Whether it is a regulation or it is a rule, we do not find. It's a subordinate legislation or delegated legislation, we don't know. Any document which has a which creates a legally enforceable right can only be looked into.
But may
Upon laws of the university. Laws of the
That may I place reliance.
First statute. আমাদের এখানে হচ্ছে the first statute, the university can enact a first statute under the powers of the act.
Lord, may I come back to this limited extent?
But
Possibly
every time when I put a question to you,
I have never sought to come back, Lord. I have always attempted to.
True, but you are not.
Lord, there is an answer to this question.
You hand over, probably it does not appear that you have gone through the entire.
I have, Lord, there is an answer to this question, Lord, but I am unsure about one point before making a submission. I do not want to make an incorrect submission. I just have to check one section with respect to one point is already on record. That kindly allows me to come back.
Give it back.
Page 129, section 19 and check that.
Exactly, that's why.
19 is the syndicate. Section 119 is the powers of the syndicate. So chapter 32 is what the syndicate can do. Okay. The submissions barring this are over. My lord, I will take 2 minutes to justify on this proposition, but after I have had a better and thorough reading of the act, and I don't want to make a submission off my cuff which is incorrect before my lords, which will A, not aid in my lords coming to a finding, B, possibly aid in my lords coming to an incorrect finding, which I do not want to do.
Correct.
Check. That's power. Appointed by the I don't want to answer. एक मिनट फूल उठा दिया जाए.
I got the answer.
Staying in the affirmative in my favor.
I got the answer. Yes, let us hear. Let's hear you.
Yes, my lord.
Your turn now.
Just my lord. My lord, kindly see this.
What is this? আমাদের কাছে আছে তো ফেরত দাও আমাদের কাছে আছে
Yes. Yes.
Reasoned order.
Pursuant to judgment delivered by the bench of the coordinate bench of this honorable court, my lord, this order has been passed after given opportunity of hearing to my learned friends, Madurai Kamaraj University. Kindly see the order impugned, my lord. First paragraph. In compliance of the order dated so and so passed by the Honorable High Court at Calcutta, MAT number so and so by virtual meeting was held, were held on so and opportunity of hearing has been given to the appellant petitioner above named and also to the Madurai Kamaraj University, represented by the Director Center for Distance and Online Education, Madurai Kamaraj University, Tamil Nadu. Yes, my lord.
This is the resolution of 2010. What you are reading is the resolution of 2010. There you say that you can't do it through franchising any study centers. You can't do that. Now, this case relates to pre-2010. Whether it will have a retrospective effect, all the decrees, all the whatever the accreditation which is given has been declared as void.
My lord, 2000 onward, 2003 notification was also issued by the UGC, my lord, not to regarding distance education. 2003.
That was in relation to franchising. That any franchisee
And
of any study center that you can't do that. They are saying that it is not really a franchisee. It is the university was
study center outside this, admittedly, this university is a state university. There is admitted fact, and he cannot operate outside the territorial jurisdiction of the state.
If the Indira Gandhi,
Outside territorial jurisdiction.
Indira Gandhi Open University has granted the recognition or approval.
And
are you above that particular Indira Gandhi Open University?
my lord, judgment delivered in the year 2005. Professor Jaspal, and Professor Jaspal already held. In that judgment, my lord.
Does it say that no study center, or it is through
Yes.
franchisee?
Yes.
Or
Totally barred.
private university?
My lord.
The judgment.
And
Because
that
the
is why, my lord.
They went.
That is why, my lord.
Please.
Just a minute. Kindly see, my lord, Professor Jaspal judgment. Paragraph 51. The act was amended by the Chhattisgarh Niji Kshetra Vidyalaya Swapna Sandhi Adhiniyam 2004. Hereinafter called the amended act.
The Chhattisgarh Niji Kshetra Vishwavidyalaya Sthapan or Vinimay.
Yes, ma'am.
Vinimay.
Samudaya Adhiniyam 2004.
What are you reading? Mr. Gupta, if you can't read Hindi correctly, then what to do?
My lord, some
You are
eye,
instructed
my lord, eye problem, my lord, that's why.
to read the correct one.
Eye problem, that's why, my lord, son. Then, my lord, by this amending, some provisions were substituted and some new provisions were added. Clause E, F inserted in section 2, read as under main campus. Main campus means the campus of the university where the main office of the university is situated and where the vice chancellor and registered reside and where not less than three university teaching department and schools are located. Then, my lord, Sumoto, kindly see, my lord, next paragraph 54. .1. Paragraph 54, 3.1. Each private university shall be established by the separate state act and shall conform to relevant provisions of the UGC.
Contention is that by virtue of this adenia, the amendment was brought to
That I am coming, my lord.
competition to the private.
Kindly see, my lord,
outside the territorial jurisdiction of the Chhattisgarh. This was declared by the Supreme Court in this judgment to be ultra vires because Article 240.
Yes, my lord. That is paragraph 6.
Extraterritorial operation of the State Act. This is what the court has said. But so far as the
Paragraphs, that is paragraph 60, man. That is paragraph 60. My lord, got it. Dr. Dhawan has also drawn attention of this court to certain other provisions of the Act which were effect outside the state Chhattisgarh. Thereby the state enactment and extraordinary operational section 2F of the amended Act confines off-campus center, which means a state of the university established by it outside the main campus, within or outside the state, operated and maintained its constituent until unit having the university complements of the facility, faculty, staff. Section 2G defines offshore campus. It means campus of the university established by its outside the country, operated the maintain its constituent unit, having the university's complements of facility, faculty, and staff. Section 3.7 says that the object of the university shall be established the main campus in the Chhattisgarh and to have study center at different places in India and other country. In view of Article 245(1) Constitution, the Parliament alone is competent to make laws for the whole or any part of the territory of India, and the legislation of a state may make laws for the whole or any part of the state. The impugned act, which specifically makes a provisions enabling university to have an off-campus center outside the state, clearly beyond the legislative of complete competence of Chhattisgarh University. It is already held, paragraph this. And my lord, kindly see 61 last page, paragraph 61, last 4 lines, my lord. However, it cannot be necessary to examine the challenge raised in the amending act in details. We have clearly held the section 5, 6 of are wholly ultra vires.
One has to understand that what is that section 5 and 6. which is extensively quoted in paragraph 51 of the.
64, kindly see, my lord, 64 and 65. Paragraph 64.
With deepest of respect and humility at our command, we are requesting you to consider paragraph 51, where section 5 and 6 have been extensively.
Declare ultra vires, my lord, by the Supreme.
What was that section 5 and 6 which is declared as an ultra vires?
That
What does it say?
section 5 and 6, my lord. I have to check up, my lord.
Take up. You are reading this judgment and this
My lord,
judgment is extensively quoted.
just
Please come to page 4, 5, 6 of the judgment, where pending act section 9 has amended section 5 of the principal adhinia.
yes.
This was declared to be void. Then paragraph 54, your UGC Act and the regulation is also quoted.
Yes.
According to the learned judges of the Supreme Court was very important.
Paragraph 40, 44. Yes.
Regulation 3.1, 3.2, 3.6 and 3.7 have been quoted. 3.1 talks about
Yes.
private university shall be established by a separate state act and shall conform to the relevant provisions of the UGC Act as amended from time to time. 3.2 says the private university shall be a unitary university having adequate facilities for teaching, research, examination and extension services.
Paragraph 55 onward, my lord. Paragraph 55.
4 at page 4, 5.
Regulation 3.3, my lord. Restrictions.
Capital D onward, please read.
Paragraph 55, my lord. Regulation 3.3 puts restrictions on establishment of the university outside.
I am inviting your attention, sir. Paragraph 5.4 at page 458 of the reported judgment of SCC.
Yes,
I do
sir.
not know. You are reading SCC or what?
Yes, SCC.
Please.
I am reading, my lord, paragraph 55. Paragraph 55, my lord.
What starts with?
Paragraph 55 regulations.
I am talking about
Regulation 3.3 put restriction on establishment of a university.
Just below it, I am beseeching with folded hand to read that.
Sorry, madam.
Please come to placetum D of paragraph 54, just above 55.
Yes,
This
madam.
is your regulation.
Yes, madam.
With 3.1, what it says?
Yes, madam.
Every private university shall be established. Does it talk about the private university?
Yes.
3.2 also talks about the private university.
Yes, madam.
Then 3.6, the program of study into a degree and or postgraduate degree diploma offered by the private university shall conform to the relevant regulation norms of the UGC.
Yes, madam.
Then 3.7, a private university
Yes,
shall
madam.
provide all the relevant information. And then paragraph 55, you are reading that
55.
regulation 3.3 puts a restriction on establishment of the university outside the state. Means
Outside
the
this.
private university coming under Schedule 1 of the Adhiniyam.
Yes, my lord.
So it is in that relation.
Then onward, my lord, 56 also, my lord, dealt with the
56 is only the argument which is advanced.
and last two paragraphs, my lord, can you see? Paragraph.
Say that the section 5(1) of the Impugned Act that permits the establishment of the university by an executive action, that is the issuance of the notification in the Gazette, which was argued to be illegal. And say that the University Grant Commission is the law, then regulation 3.1 was referred. And 57 talks about 3.1. A private university can only be established by a separate act. Paragraph 57. In view of the regulation 3.1, a private university can only be established either by separate act or by one compendious act where the legislature specifically provides for establishment of said university, means the private university. Though an attempt has been made in section 5(1)(b) of the amended act in this regard, but the same does not conform to the regulation, inasmuch as the initial notification notifying in the official gazette that the university is established is done by an executive order and not by an act of legislation. This is what it says, that's ultra virus.
Yes. Then last two paragraphs, kindly see, my lord. Last 64. My lord got it.
This is what is all the private universities have ceased to exist because they have extended their territorial jurisdiction. And their establishment was in terms of the executive order, not in terms of the statutory provisions. And that is why I say that it will cease to exist.
Thereafter, my lord, several notices has been issued by the UGC, University Grant Commission.
Your counterpart was there in the meeting. The approval was
Yes.
granted in their presence.
No.
You did not do anything.
My lord, kindly see the order passed by the pursuant to. Kindly see the order, my lord, passed by the UGC, my lord. On the last occasion, my learned friend dealt with 35 DEC meeting. Paragraph 3 onward, my lord. Paragraph 3. Madurai Kamraj University. My lord got it. Madurai Kamraj University, Madurai, Tamil Nadu is a state university. The Madurai Kamraj University.
They are the state university.
This
Madurai Kamraj is the state
paragraph 3.
Yes.
Paragraph 3 of the order, my lord.
Of what order? Reasoned order.
Order passed by the University Grant Commission, pursuant to judgment delivered by the division bench of the coordinate bench of this honorable.
Have relied upon the
Yes, ma'am.
judgment. One has to consider whether you have correctly applied the ratio of law laid down in SPAR or not. If it appears that you have not applied the correct principle, then in that event, one has to understand.
Professor, thereafter, my lord, several public notices has been issued by the University Grant Commission.
Then the question would be that it will take effect from
That I have annexed, my learned friend also annexed one of the notification, my lord, public notification.
that was of 2013.
No, 2009. My learned friend also annexed, my lord, page 34 of the affidavit. Territorial jurisdiction of the state university. 2009 onward, there are each and every year this notification has been issued, public notice, to stop franchising as study center. Study center, not only franchisee, study center outside the territorial jurisdiction of the state. My lord, can a Calcutta University establish a study center in the state of UP? I am asking myself. Cannot.
That Manipal University is set up here.
No, my lord. That is Tamil Nadu. This is Madurai Kamaraj University.
When you are talking about the proposition of law, University Grant Commission exercises jurisdiction throughout the country, regulating the educational organizations inside the country.
Yes, well.
You are the central act.
Yes, well.
So how then we'll have to see that how these universities are operating outside the jurisdiction of the state.
Then, my lord, not only this order, my lord, several other orders passed by the coordinate bench of this honorable court on the basis of notification. I have already annexed in the passed by the division bench of the Honorable Mr. Justice Dipankar Dattu.
Why you are talking about the UGC letters of 2008 and 2009, sir?
2009, my learned friend annexed.
It relates to the academic year 2006-07, not beyond that. Even in 2008 and 9, you have said institutions were instructed to immediately close down any off-campus centers and the centers operating through franchisees. If
My lord,
opened by the
not only that,
established through state act outside the territorial jurisdiction of the state in view of the judgment of the Supreme Court in his power. Then,
study center as well as franchisee as well as
franchisee is not a case here. They are.
My lord, study center. My lord, study center. My lord, kindly see my affidavit.
Paragraph 6, what you have said in your reasoned order.
My lord, kindly see my affidavit also. I have also annexed.
Meeting.
Yes, my lord. Kindly see the order impugned. Order passed.
We are not concerned with the order impugned. We can set aside the order. Are we
Yes.
bound by that order?
Yes. No.
We have to test on the basis of the overall facts and the law.
Yes,
we
my
are
lord.
just trying to ponder upon what is a fact and what is a law.
Yes, my lord.
The single judge may have committed error. So division bench, what for it is sitting? To see that whether it is correct in accordance with law. Please come to your own stand. Paragraph 6 of that reasoned order.
Yes, my lord.
It says that white letter dated 4th August 2003, issued by the Worldwide Distance Education Council, wherein it is clearly mentioned in serial number 9, territorial jurisdiction for offering program through distance mode will be as per the decision taken in 35th meeting of the District Education Council. This is your stand. In 35th meeting, the council noted that the distance education and the online education cannot have the territorial jurisdiction. Consider,
Yes.
you eradicate the concept of territorial jurisdiction. In case of central university and state universities,
Yes, my lord.
the territorial jurisdiction will be as per their acts and the statutes for offering programs through distance mode. So you recognize the territorial jurisdiction in case of deemed university, that is a different one, will be as per UGC, which mandates the prior approval of the UGC for opening centers, off-campus centers outside the headquarters. You say you can, but without my permission, you cannot. Prior approval is required.
Yes.
Territorial jurisdiction in case of a private institution and other than university will be decided by a joint committee, which has decided that the territorial jurisdiction for the institution, both private as well as government financed,
Yes.
shall be headquarters and no case outside the state.
Yes.
So two things. One is the private and government funded. You cannot operate any campus outside your territorial jurisdiction. But so far as the state universities and central universities are concerned, you say that they will be guided by their own act and the regulations. Their act and regulation permits the establishment of the study centers, not through any private intervention, but not through franchising, but they themselves.
Next paragraph, kindly see the next paragraph, my lord.
You say,
Yes, my lord.
Distance
10.
Education Council prohibits franchising.
Of
the
study
study
center,
center.
franchisee of study center.
What is the meaning now? Let us
Study
understand.
center, study,
By franchising.
study,
First, Mr. Gupta, then one has to understand the meaning of the word franchise. What do you mean by franchise? Let me understand that
My
what
lord.
is the meaning of the word franchise?
It shall be, my lord, study center is established outside territorial jurisdiction of the state, number one. And secondly, my lord, in between them agreement or whatever may be, that has been contact and that has not been given by the UGC approval. UGC not approved. Any franchisee of study center, he established a study center outside of the state.
Fine. This is your own case, sir. Paragraph 6 has to be told off, according to you.
My lord,
Told off. It has got no value. If you do not understand your own decision, then what you expect from the judges?
my lord, kindly see.
It is your decision.
My lord, kindly see
You
page.
have to go by your own decision.
That's right. Kindly see paragraph 12, my lord. He,
Serially, how you have agreed, how you have.
my lord, paragraph
You have
12.
said from 2008 onwards, we have been harping. Now let us see that what you harp upon. This is what in 2008-9 you harp upon. You say, yes, university, if their act or statute permits,
But
we have nothing to say.
but
But after Yashpal, private entities, franchisee, study
But-
centers, not permissible at all.
But
Will be
but
completely
but
shut down.
should be, my lord, but should be within the state, not otherwise. Paragraph
You can't
Ma-
put,
paragraph. No,
Yashpal also does not talk about that the university cannot open a study centers within the state through franchising.
But
The
UGC,
Yashpal does not talk about that the university cannot open any study centers within the state.
thereafter, my lord,
You are talking something different than Yashpal.
my lord, thereafter, my lord, several notices has been issued. 2009, 10, 11, 12.
Notices we are reading. This is the notice you have read. Sir, my English is very bad, but I do not
No,
know.
extremely sorry.
Of
But
this
my lord,
word.
on the last,
In
on
case of, this is your.
my
you
lord,
have
paragraph,
that the distance education council set up by you. Yes.
asked by, not now, my lord, asked by, yes, my lord.
You have said in case of central universities and state universities, they are the state universities. What the territorial jurisdiction will be as per their act and statute for offering programs
Right.
through distance mode.
Right, my lord.
Correct. To say that their act for distance mode will apply. Territorial jurisdiction, then you say, in case of deemed university, they are not the deemed university, will be as per UGC. You say that as per me,
Yes, my lord.
which mandates what? The prior approval of the UGC for what? Opening centers or off-campus centers outside the headquarters. Then you say the territorial jurisdiction in case of private institution or class other than universities will be as decided by joint committee, which has decided that the territorial jurisdiction for the institution, both private as well as government funded, shall be headquarters and no case outside the state. So you say it's a private or government funded? No. If the university, state universities takes a decision, Can you bring it this within that? I am
My lord, thereafter, my lord, several, when the UGC taken over, my lord, thereafter several notice has been issued.
Serial number 10, you say that the Distant Education Council prohibits franchising of study.
Study center.
So franchising completely bar. Bar.
Yes, my lord.
Thus, your institution will not franchise any study center. You have said very, very clear.
Yes.
So one has to understand franchising. What is the meaning of word franchise? In a commercial parlance, franchise means if a person does the thing of his own, by himself, by itself, does it mean franchising?
But my lord, what? My lord, thereafter, my lord, several not.
Thereafter, read. Thereafter. When you say thereafter, then read thereafter. It was further mentioned in the said letter that before launching the program, the institution should submit an affidavit within 30 days from the date of the issue of this letter that it agrees to and will abide by all terms and conditions contained in the said letter. In case the DEC does not receive the affidavit, now you have given it to DEC, does not receive the affidavit within 30 days from the date of issue of this letter, the approval accorded to your institution will be considered as withdrawn.
Yes.
Whether it is found that the institution is flouting any norms, then the recognition according to the institution will be withdrawn without any notice. Then he takes her to the DEC decision, which he referred at page 28 of the affidavit submitted by the university of 12/9/2008. By a Distance Education Council, whom you have said that you should follow that norm. This is what is there. Second paragraph. Have you got that page 28 of the affidavit of the Kamara? I think I have to argue for them, for you, before you. It appears to me that I have taken a brief for them as a lawyer to make you understand that what is passing in our mind, so that a clarification may come. Please read this 12/9/2008 letter issued by a Distance Education Council. What it says, second paragraph. In this connection, we'd like to inform you that based on the recommendation of the expert committee that visited your university, the chairman, Distance Education Council, has accorded post facto approval to your university for programs offered through distance board with effect from 1st March 1995 to academic year 2006-2007 as per enclosed list as Annexure 1. What does it mean?
That is 2008. Post facto approval was given for. Yes,
By whom? The District Education Council. And you are relying on this, your own document.
Yes, sir.
Where you are saying that in case the DEC does not receive any affidavit, so the power is given to DEC, then your approval will be withdrawn. So DEC has given a post facto approval for up to academic session 2006-07. That's all. Not beyond it.
That is 2008 later, my lord. Prior to that.
Prior to that, what are you talking about?
2008 later.
But this is a September.
And with effect from March 1905 to 2007.
2006-07. Yes.
6-7.
Correct.
Yes, my lord.
Yes.
During this period only.
True. Not beyond it. Who says beyond it? For this period only. And the degree in question is for that period only.
But, my lord,
means what?
Whether he has obtained
of 2008 academic session, I can understand it is beyond.
But whether for that period, my lord, whether he has obtained permission from the DEC or not, that is also
by a DEC.
DEC has given a post facto approval, but
Rightly,
before
wrongly it has given. You say that a DEC has all power to withdraw that approval.
DEC,
Yes.
but prior to that, whether any, my lord,
Please, in your own way.
my lord, whether before starting, my lord, study center, he has given permission to the from the DAC or not? That is also a question.
What?
Before starting, my lord, franchisee or study center, my lord, he has obtained permission from the DAC.
Sir, when the word post facto approval is used, that implies any common a man of a slightest perfect intellectual will understand that the prior approval was not given, was not obtained. Any slightest person of perfect intellectuals will come to this. Yes, prior approval was not granted. Then there's no question of using the word post approval, post facto approval. Post facto approval means what? You have already started. You should have asked for prior approval. Having not, now I'm giving you a post facto approval. It will relate back to. It was who says that they obtained prior approval? No, they did not.
My lord, kindly see, my lord, page 81. 31 of the said affidavit.
See, the Madurai Kamraj affidavit.
Yes, 31.
Certificate, my lord, certificate, my lord, saying page 31.
They may have granted a certificate, but for the
2009, my lord, post facto approval was given prior to 2008. And this certificate, my lord, compliance 2009.
Or he will not read. That is the whole problem with him. But that's why I exhausted. Please.
2006 and 7. The period, my lord, 2006 and 7. Period all mentioned here, man.
You passed class 10 examination in 1972. Certificate of pass was issued in, say, 1980. Will you say that they are incompetent to issue? You passed in 80. Because you passed.
2009 certificate is a period mentioned, my lord, 2006 and 7.
Within that particular mischief of post facto approval. Yes, after that, what has happened to Sukanto matter?
In the unfortunate facts and circumstances, Mr. Majumdar, Shumanto Majumdar did not assail this order. Had the order been assailed, in that facts, in more, if my lord allows me, I could have brought those documents on record. I could have shown each day from 2007, even thereafter, that accordance under the aegis of the UGC, I was given to run my university and offer degrees. I had shown before that court that it's recorded in the order. I can place if my lord so pleases. But if that would have been assailed, my lord, in my understanding, this order, this recent order, wouldn't have reason. Because this order in one place goes on franchising, so that franchising is bad in the recording of the facts, but orders that study center is bad.
2009 notification by one notification annex, another notification not annex, which clearly mention my lord to stop state and state private investment.
Not retrospectively.
Where?
My lord, can you see this? No, this
Which one? This is here in company.
from my affidavit, my lord.
Your affidavit.
Two notifications were issued in 2009. 2009, my lord, two notifications has been issued.
Counter affidavit.
Which one? You will counter or normal affidavit?
Which one you are referring? Which affidavit?
My lord,
Counter.
counter affidavit. 2000, page 20 and 21. Start from
This is the 15th June 2009.
19.
Not 99. 15th June 2009. Page 20.
Page 20, my lord.
Please ascertain because I am.
Page 22, also appearing at my affidavit.
Oh, what he's referring.
Yes, what he's referring. I have
State
page
university and
21
private
my
university,
learned
both.
senior friend's affidavit. It is also
One is the continuation of 20.
Milord of the counter affidavit, Milord.
Yes, counter I am saying.
Counter affidavit of
reply on behalf of the added respondent. Upon by Dr. Naresh Pal Meena.
Yes. Yes,
Yes,
by
sir.
Dr. Naresh Pal.
Page 20, my lord. I am referring page 21.
Page 20 is continuation of page 19, annexure R3. Annexure
Roman
R3.
II, to stop all the state and state private universities.
Starting one. Page 21 is the continuation of page 20.
Possibly then the pagination handed over to us is different, Milord. May I just, page 20 starts with the word keeping and ends with the word franchises, Milord.
No, that's why I'm asking whether it's the letter of 15 June 2009, what he's referring to.
If 15 June 2009 is the letter, Milord, that is starting at page 21 of my affidavit and possibly.
This is starting at 20 in my affidavit.
Milord,
What is referring?
My lord, can you see page 19 onward, my lord, two notifications issued in the year
Milord,
2009.
my learned senior friend is referring to a letter of 16th April 2009. Page 19 here.
Page 19, page 21. Two notifications. Page 19 and 20. Yes, my lord.
You have filed, you have paginated it. Anyhow, we are not going into that.
And
aspect. Page 18. I have
15th.
asked the date, 16th April 2009.
My lord, 15th June 2009.
Page 20.
What I was, that is there in the next letter. Anyhow, tell us what is this? What you want to read?
My lord,
What is
state university and private university both are restricted.
Where do I find that? Tell me,
Well,
sir, let me understand.
Territorial jurisdiction of 15 June.
Yes, please.
Territorial jurisdiction of state university and state private university.
Read it, sir. I've read at page 21, the last.
Also annexed to my.
I've read it. Let him read. Let us see what he understands from the meaning.
Kindly see, my lord, page 20. Also, my lord, page 20, 20. II, to stop all the state and state private university in the state from operating beyond the territorial jurisdiction of your state in any manner, either in the form of off-campus study center or affiliated college, and the centers operating through franchise. Operating through franchise. Totally barred. Then this is also repetition, my lord. 15 June.
Read plus the read it.
Page 22, my lord.
Read it, sir. What do you say? Keeping in view.
Page 21. Territorial jurisdiction of state university and state private university. Next page, kindly see, my lord, only to ensure that no off-campus center, study centers or affiliating college and the centers operating through franchisee is opened by your university outside the territorial jurisdiction of the state in view of the judgment of the Honorable Supreme Court in the case of Professor Yashpal versus Government of Chhattisgarh. Next, in case of university has already started any off-campus study center, affiliating college, the center operating through franchisee outside the state, it should be closed immediately. Everything mentioned, my lord.
Everything mentioned, no.
Then third, no distance education programs shall be started without the prior approval of joint committee of the UGC, AICT, DEC, for which DEC is the coordinator. Therefore, my lord, since
What happened prior to it?
prior to that was notice was issued, but whether any, my lord, I am asking myself, where
You say immediately you stop.
Yes,
You will
sir.
not, you will not.
If already been started, then immediately should be stopped. That notification has been issued.
Prior thereto?
Prior to that, my lord, only I am asking, my lord, before establishing study center, whether any information has been given to the DEC or not.
Then why DC granted a post facto approval up to that? Why?
Then
Because you say the PC, the coordinator, everything will be done, then why it granted a post facto approval?
that is mentioned, my lord. At that point of time, DEC was controlling. Thereafter, my lord, UGC is controlling.
So, I think the
That
UGC
point I am leaving to your lords.
was prior thereto.
But Professor Yashpal, after passing the judgment passed by the Honorable Supreme Court, well, several notices has been issued.
You are more, I think, you are keeping more adherence to Dr. Yashpal's judgment, nothing more than that. You will say so. You will consider.
Just a minute, one, I remember one.
Yes, I will consider that Dr. Yashpal's judgment. Anything more? You can't improve, I think.
Just a minute.
Yeah.
I am handing over, my lord. Madras High Court judgment delivered. Several universities has filed, my lord. Online একটা page. একটাই আছে. Several universities, my lord, have filed, and including, my lord, appeal filed by the UGC.
For
I am not giving much trouble, my lord. Kindly see, my lord, paragraph 60.
Paragraph
60, 60. In fine, we conclude. Yes, sir. Several universities.
Just 1 minute. নামটা বলবেন? আচ্ছা অনেক একটা কপি দাও না।
একটাই কপি নিচ্ছি না, শেষ করে আমি দিয়ে দেব।
I have read paragraph 60. That's your case?
Yes, my lord.
Thank you.
And all the writ petition dismissed, only University Grant Commission will prevail over, and that writ petition was allowed.
Thank you.
So this is my submission.
Are you sure that you are relying on this judgment?
My lord, I am just
We can
came to
write
know
it.
my
The judgment we have to write. That's why we are asking.
several on the basis of
No,
Professor.
are you sure that you are referring this judgment? Relying on this judgment?
My lord, I'm not entire. I have gone through, my lord, but I
Again,
can.
as a
I
counsel,
do
when
not.
you are referring, that means we will take it that you have referred it and relied upon.
Professor Espal, my lord, on the basis.
Mr.
Professor.
Gupta, I am asking you a very simple question. I think the English language is so simple as I have used that anybody can understand. We are simply asking you, are you sure that we will take it that you have relied upon this judgment?
My lord, I am leaving to your lordship, but
What leaving to your
it
lordship?
appears
First thing is, we must treat it as
in
the
that.
judgment referred by you and relied upon by you. We have to write it. He has relied upon, we will
Yes.
consider.
On the basis of Professor Espal.
Yes. That's it?
Yes, my lord.
Thank you.
This is my submission.
You have nothing to say.
My lord, in behalf of college, my lord, I am appearing. My lord, veteran of 2012,
What college?
Calcutta Christian College.
Who are you?
My lord, I am
No, I tell you, Lordship, because I was appointed in the Bakura Christian College as librarian.
My lord, at the relevant time, my lord, as per UTC rules, my lord.
Not
That-
appointed.
Oh, appointed on the basis of this degree.
No, I tell your losses.
My lord, he was given appointment, and that appointment was subject to the approval of Director of Public Instruction, my lord. At the relevant time when he produced the all documents, that time he has produced the net certificate, he was not qualified net. And after that, he supplied the MPhil certificate from Madurai Kamraj University. But MPhil is not the requisite qualification for that post. My lord, that is my lord.
What is the requisite qualification?
PhD, not MPhil, PhD. My lord, that is PhD. My lord, that is my lord, I have submitted my lord as per UGC rules. But specifically stated, and also when government of West Bengal, my lord, my lord, can you see the second volume of affidavit, my lord. Second volume of affidavit, my lord, page 171, my lord.
Page 171.
171.
Yes.
My lord, 171, my lord. 172, my lord. 172.
172.
Assistant library of college librarian. However, candidates who are or have awarded PhD degrees according to the Environment Commission.
Where? Deputy librarian or what? Assistant?
University assistant
It's
librarian.
for clause, tell me 4.5 point what?
4.5 minus 3, clause 3.
A master's degree, information science, documentation.
Roman 3, my lord. However, Roman 3. However, candidates are or have been awarded PhD in accordance with the standard.
He has a master's degree in library science.
Master degree, but compulsory PhD, my lord.
Who says compulsory?
My lord,
Says that exemption, PhD, then minimum qualification does not require exemption.
exemptions for net or slay. My lord, not, my lord, clause 3, my lord, my lord.
There are two aspects. You please, madam, according to you, he has not fulfilled this net, slate and set.
That is, but PhD is compulsory, my lord. My lord, thank you, my lord. And another, my lord, circular.
Talking about, madam, again,
My lord, on
I
the
think you are sitting by his right side, that's why you become so much,
no,
some energy has gone. Please read it, sir. And English is very simple. Please read. You have read it, please read again clause 3.
clause 3, my lord, I
Please.
read, my lord.
First thing is clause 1. Read. Again, I have to read for you.
Yes, my
A master's degree in library science, information science, documentation science
not,
is, you have to be there.
yes, my lord.
Or an equivalent professional degree with at least 55% mark or an equivalent grade in point scale wherever the grading system is followed, and a consistently good academic record with knowledge of computerization of the library is a minimum qualification. 2. Qualifying in the national level test conducted for the purpose of UGC by the UGC or any other agency approved by UGC. So
But
these are the
that one,
these are the two conditions, that you must have a master degree in library science with 55% aggregate, and
net
you must pass the national level test examination conducted by the UGC. Then come to 3. It starts with, however, candidates who are or have been awarded PhD degree in accordance with the University Grant Commission Regulation 2009 shall be exempted from the requirement of minimum eligibility condition of NET, SLET, SET for requirement and appointment of the University Assistant Director of
We are not.
for whom? So what it says that if he has a PhD degree, then national level test is not.
But he was not.
But he must have the MPhil, a master's degree.
No, PhD is also compulsory.
Compulsory. Suppose a person has the master's degree. He has also qualified anything. See, I am telling. He has a master's degree and also qualified national level test.
National level test he has not
Please,
qualified.
I am asking you, madam.
You
Can you say that you must have a PhD degree? I'm asking. Take a hypothetical example. A candidate has the master's degree in library science and has also passed the national level test. Do you insist that the PhD he must have?
No. If
So,
yes,
so PhD is not mandatory.
then NET if he has
It is only for the purpose of NET. That if he has a PhD degree, then he is exempted. If he does not have, so minimum qualification,
up
the
to NET.
masters.
Up to NET.
His minimum qualification is master and the passing of NET. That's all.
But NET was not qualified.
Then he does not fulfill the eligibility criteria. If he has PhD, then the exemption will come.
Neither NET, NET, not PhD. Nothing he has. Only master degree. But college librarian, either you are either NET,
My lord,
national eligibility test or PhD. He has not qualified the NET or PhD. Nothing, my lord.
Suppose if he does not have 55% aggregate marks in MSc, but has a PhD, then what you say is correct?
No, minimum qualification.
Oh, one has to understand minimum qualification and exemption. Both stands on a different footing.
My lord, the government of West Bengal notification is also there, my lord. Kindly see that PhD, if he is completed PhD, then exempted from NET. Exempted from NET. My lord, he has neither NET qualified nor PhD degree. That's why, my lord, he has not requisite
That is the correct way. But the way you were saying was wrong.
No, that is my
my lord, I am not, my lord, I am not.
He does not have NET.
No.
You have PhD?
PhD degree I don't have.
My lord,
But I tell you, lordships, these regulations has been amended or qualified. Now MPhil is enough.
No, that is
at the time of
At the time. And that has been considered by the
at the time of examination.
at the time of recruitment.
no.
This has been amended.
Amended subsequently by UGC.
No. Examination was conducted under this
2012.
notification. Under this notification.
Under?
This notification, which is she's referring at page 169.
Well, this itself has been amended after. I get your lordship's point. Yes.
What is coming here?
No, not for the for this.
For this.
For this.
They amended.
Amended. And that the
Where is that?
your lordships will find it at page 101.
101.
Sure.
Now your lordships kindly come to
101.
101. At page 102.
It's 11 July 2016.
16.
What it says?
My lord, kindly come to the next page, proviso. 102.
Yes.
Provided further. Last paragraph. The award of degree to candidates registered for the MPhil or PhD program prior to July 11.
I could not get it.
The last paragraph. Four.
Provided further.
Further,
Yes.
that the award of the degree to candidates registered for the MPhil or PhD degree program prior to July 11, 2019 shall be governed by the
Nine.
shall be governed by the provisions of the then existing ordinance, bylaws, regulations of the institutions and awarding the degree, and the PhD candidate shall be exempted from the requirement of NT LCT said requirement for appointment of assistant professor or equivalent positions in the universities, college, institutions subject to the fulfillment of the following conditions. Now, this was considered, my lord, in this appeal by this division bench, my lord, presided over by the Justice Sen. That's at order dated 13 September 2013.
What?
My lord, your losses, look at the order, your losses.
Yes. What it says?
My lord, this is page 20 of your loss.
It's in relation to a librarian. It is not in.
A librarian is a teaching post now.
Huh?
Librarian is a teaching post now.
No, he's a assistant professor.
My lord, it's equivalent to teaching.
What are you talking
My lord, that's the judgment, our High Court judgment, and then throughout the country. It is accepted, my lord. I think Mr. Gupta will not join an issue with this. Librarian is a teaching post.
That's right.
Lord, the order I have annexed your lordships at page.
Madurai Kamraj University's affidavit.
My lord, Madurai Kamraj University's affidavit, if your lordships kindly take up.
Does not talk about the dispensation of the MPhil.
My lord, your lordship, this MPhil, if I MPhil, my lord, I will have the dispensation of name and slave.
No.
That's your lordship.
My reading may be wrong. Please read it again slowly.
Provided further, the award of degree to candidates registered for the MPhil / PhD degree prior to July 11, 2009
shall be governed
shall be governed
of then existing ordinance, bylaws, regulation of the institutions awarding the degree, and the PhD candidates shall be exempted from, and the PhD requirement of NET. Following conditions, they have imposed rather further conditions relating to exemption of the PhD candidate, that the PhD degree must be in a regular mode. Then the evaluation must be done by at least 2 external, then open PhD viva voce, and these are the candidates. MPhil does not come under this.
Malad, that's your losses, Malad. Your losses, Malad. This comes your losses. Malad, your losses can leave a look at.
My lord, I am.
Would your losses give me a day's time? Because I will be out of station.
My lord, I do not want to rely upon that judgment. I want to take it back. My lord, I do not want to rely.
No, we will rely upon, but not in your name.
No, my lord, I am praying.
Kindly keep it on.
My lord,
My lord, not taken up, my lord, then my lord, 11, my lord.
Tomorrow.
My lord, tomorrow.
Friday.
এই সোমবার হবে না গো, আমি
Lord, I beg to appear on behalf of the West Bengal State University.
Lordship, I appear for the petitioner. Lordship, on the,
Order under appeal is at page 56.
Lordship, the petitioner is a 45-year-old lady.
What is this application?
Lordship, application for appropriate order.
The appropriate order according to.
Lordship, petitioner is a meritorious student.
Is disposed of.
Lordship. Lordship.
Lord, order under appeal is at page 56. Stay application, my lord.
Oh, everything appropriate order. Not only to hear, but also admit the appeal and then also quash the order of
Trial court.
by appropriate order. How can it be done? Very alarming. That's a very alarming. How can you ask for this kind of an order?
What
What has happened to the criminal case?
Your charge sheet is similar, trial is.
There are some what?
Lord, I have to take instruction. Lord.
The petitioner is a very meritorious student.
Victorious and could not pass in some subjects.
Lordship, petitioner applied for the review, and the review the petitioner was declared as pass.
And approached university in
There was-
23.
All the fake certificates, even a review,
Yes.
Lordship, she was
everything was a fake one. The FIR is lodged against the then.
There was a controller was suspended.
Lordship, after filing the
Controller suspended.
after filing
If your you know, this was, I think the certificate is found to be genuine, then they will consider. Unless that is held to be genuine, it can't be done.
Lordship, the college authorities never appeared in the
They
during
are
the
hand in glove with the Lord, at that point of time.
The
The then
petitioner was not at all
controller.
aware of what
Examination.
was the fake certificate, how it was issued. She was not at all aware of
Kindly
the
see
same.
the conduct.
Madam,
Kindly see the conduct, my lord. 2014 appeared examination. She failed, approached the university in the year 2023.
The petitioner is a
9 years.
45-year-old lady.
9 years.
your marks in the class 10 examination.
Lordship. The secondary, it was 554. First
This is division, first division.
division.
First division, high secondary examination, second division at page 18.
The tuition was there.
But Lordship, she secured masters in 2 subjects, that is music and education.
Netaji Open University. कागज देना नाम दिए
How would it go from science to music? These also very bad results.
Lordship, but there are similarly placed candidates. I came to know from the college after filing the said application that they were given a second chance of sitting in a similar examination in spite of the review.
Lord, if your Lordship kindly sees, one thing, Milord, may I point out? Lord, if your Lordship kindly sees the application for appropriate order, your Lordship kindly sees, Milord, page 43, kindly sees, from the document itself, it is clear that forged document has been relied upon. Fake document. 43, has your Lordship got it, Milord?
I was looking at 40.
Milord, 46, your Lordship kindly sees, Milord, this is the mark sheet she is relying upon that he has passed after review. Milord, kindly sees the date, post review, 19th August 2015. At the bottom, has your Lordship got it, Milord? And second, Milord, your Lordship will be astonished to see, this is the Milord B.Ed semester 1 and 2 examination. Same date. And if your Lordship kindly goes through the original mark sheet, which has been relied upon before the trial court, Milord, your Lordship kindly sees. Lordship din na?
Petitioner has approached the university several times.
The registration number is one and the same.
Milord, your Lordship kindly sees.
It is same.
It is in my report what has been
Lordship,
that
it is
has
same.
been which has been
Same.
yes, Milord, your Lordship kindly sees annexure A 1420 in the paper 1 DEIC. Has your Lordship got it? Annexure A 34 he has spelled, qualifying marks is 40. Thereafter, Milord, this is the Milord, the in second annexure B, kindly transfer to this next page, Milord.
44.
Milord, your Lordship kindly sees 7th, 8th, 9th and 10th paper, Milord. Your Lordship kindly sees, this is the genuine mark sheet, Milord. And your Lordship kindly sees result at the bottom. Has your Lordship got it, Milord? PNC. That means, Milord, part not clear. Because since he has failed in the Milord semester 1, that's why this is the genuine mark sheet. Part not clear. And date, your Lordship kindly sees 19th August 2015. And now your Lordship kindly comes to the writ petition which I Milord application for appropriate order. Milord, your Lordship kindly sees page 43. This is the fake mark sheet he has been relying upon. 19th August and marks is Milord 40. And next page, Milord, that is also Milord fake mark sheet at page 44.
No, why fake? You are relying on this. So the marks are one and the same. Not a fake one.
Which one, Milord? Page?
Result is passed and class is one, first division.
Milord, your Lordship is looking at, Milord?
Page 44 with
44, Milord, it's a fake mark sheet.
Annexure B. Fake is only to the extent of result
Passed.
And class 1.
Yes.
It's absent.
Yes.
And so far as the percentage is concerned, total marks, nothing is there.
Milord, kindly see the Milord date.
Date is 19th August. I've seen that.
Yes.
Earlier one is 5th August. That is August.
Lordship, Milord. And Milord, one thing your Lordship kindly appreciates conduct. Milord, she appeared in 2014. Appeared in 2014. Approached the university in the year 2023.
Lordship, the college authorities on being informed about the appeal being filed, they have Lordship kindly goes to this. Lordship kindly goes to this once. দিচ্ছি। Similarly placed candidates, they were given an opportunity of applying
that
for the
controller,
examination for the second time.
That controller
Lordship,
who has been
I'm
charge
asking
sheeted.
the question to myself.
Or we uncleared paper which you could not pass in the first semester. You can appear, there is no difficulty. They do not say that you cannot. Your case says that no, I have applied for review, and in the review, the marks were increased by 6 marks. So you qualify as a 40 marks. So you have already cleared first semester. And therefore, second semester you said you have been given this particular the certificate or whatever the mark sheet.
Lordship.
So according to you, you have secured a pass marks in both the semesters and have secured a first division. Their condition is no, the review does not really make the additional 6 marks to be allotted to you.
Lordship.
So you have not cleared one subject of the first semester. You may have cleared the second semester.
Yes,
But you have to clear that subject.
that is
Lordship,
part of clear.
kindly allows me to sit for the
Not
examination.
if you are,
Of 2017.
yes.
Lordship, the college,
No, no, she appeared
Lordship, college authorities,
2014. She
Lordship,
appeared in the
college,
2014. Now we
college
are in the year
authorities-
2015, 2025.
What you were doing from 2017 to 2000.
Lordship, it's a mercy petition, Lordship. My father and mother both have expired in the meantime, and I'm a divorcee lady, Lordship. Lordship, mercy petition, Lordship, kindly, Lordship.
Time is the best healer. The time does not need 7 years to heal.
Lordship, kindly allows me to sit for the examination for once more.
For a some interim period, there was something which has come. For that, we can understand. But what you were doing from 2017 to 2023, and when your parents expired.
Lordship, my father expired in 2024 January, and my mother expired in 2018.
Before.
And my divorce.
Before. So what you were doing from 2014 onwards, or at least 2017, when you were relying on these documents.
Lordship, let the college authorities appear once, Lordship.
Sorry?
The college.
What you were doing, you should have come with the application 2017. Nothing you have done.
Lordship, I have approached the college authorities several times. No, Lordship, Vardwali, I have applied to. Lordship.
Believable story. Then it reminds me of Justice Krishna Iyer's very apt quoted, clever draftsmanship creating an illusory cause of action. Are you aware of that judgment? The Justice Krishna Iyer has said that the legal experts are approached, they create the clever draftsmanship created an illusory cause of action. This is the greatest example of that. Illusory cause of action. I was verbally approaching every time I was going to the college, not a written document. Believable.
Lordship, the only question I'm putting to myself, college authorities never appeared.
The application is listed today, but after hearing the respective counsel, we do not find any justification. Why should the council to address the matter 42
এই অ্যাপিয়ারেন্সটা দিয়েছি ওখানে।
Number 65, my lord, I'm the appellant. Last occasion, your lordship was pleased to, my lord, direct Mr. Mukherjee to take instruction, my lord, in the matter and directed us to serve a copy. My lord, we served the copy and, my lord, Mr. Mukherjee to, my lord.
Where is Mr. Oh, you are here?
My lord, yes, my lord, we have got the instruction, my lord, from the district inspector of schools, my lord. This is an instruction, my lord, that
Just one.
it,
Only on the ground that she is a married daughter. This cannot be a ground that the family anyhow survive, maybe on the charity of the others. That does not mean that the purpose
Lord,
of professor appointment.
another thing, my lord,
Approaching the court anyhow within 5
my
years.
lord, one finding, my lord, kindly sees.
No, but there are two findings. One is that she is a married daughter, cannot be accommodated. Second, she has approached the court belatedly after 5 years from the date of the rejection. So,
My lord, another, my lord, there is another, my lord, finding that there is a, my lord, earlier writ petition filed before this court. My lord, that copy, my lord, kindly sees page 42.
where is that writ petition? What has happened to that writ?
My lord, the first writ petition was, my lord, withdrawn. Liberty was granted to file a second writ petition. So, your order was
So that cannot be a res judicata.
No, that was not annexed. That was, my lord, what has been submitted.
And this was done in 2020. Liberty was given to file afresh. There was no debate.
My lord, in the meantime, what happened, my lord? My lord, we have handed over a copy, my lord. In the meantime, from the district inspector of school, my lord, the hearing was, my lord, given. My lord, we attended. Thereafter, my lord, they didn't, my lord, pass any order. My lord, in the 2022. But, my lord, we have handed over a, my lord, a copy. My lord, again, my lord. Yes, your lordship, my lord, kindly see, my lord. 22nd April 22.
Yes, my lord, there is a hearing, my lord, but my lord, till date, my lord, it was, my lord, forwarded for, my lord, before the, my lord, commissioner of school education, because this is, my lord, only the, my lord, in the last week, my lord, we have sought for, my lord, as per the instruction, my lord. My lord, I beat time, my lord, my lord, 2-3 days, my lord, within that, we will take the information from the commissioner also. Lord, because we have intimated the district inspector of schools, he has given me a, my lord, copy of an earlier instruction, my lord, that is 22/11/2024, my lord, that, which I have received just, my lord, yesterday.
Oh. He submits that that the district inspector of school has stated that the hearing was held on 22/11 or 4.
My lord, 22. My lord, thereafter, my lord, it was sent.
Was held on. I have got a letter of latest is 18/8/22.
Yes, my lord. Thereafter, my lord, nothing is.
Was held on to 18/8/2022, and the entire record was sent to the commissioner of school education.
My lord.
For
on 30,
The decision. There are
30/11/2020.
It is further submitted that the district inspector of school has not received any communication from the commissioner of the school education as of now.
Madam.
The council for the state submits applies for an accommodation to take a necessary instructions from the commissioner of the
Madam.
school education. Of the above, let this matter be listed on 29th.
Madam. Yes. আমার চেয়েও পাঠিয়েছি 24 তাও এখনো পাঠিয়েছি আমি দেখতে
My lord, I am appearing for the appellant's petitioners. Lord, this is the application, Lord, for restoration. Lord. This is the application for restoration of an appeal. First appeal, my lord, which was. I am for the appellant petitioners. I am for the appellant petitioners. Yes, it has been started.
The affidavit of service.
Lord, the
Affidavit of service.
affidavit service to dekho. Lord, so far the appeal is concerned, my lord, the appeal preferred against the suit for partition, declaration and injunction.
44, 2010. When the application is taken out.
Lord,
Application is taken out.
2010, Lord, the appeal was dismissed on 11th March 2010. Thereafter, my lord, the yes, section 5 is relates to, my lord, first appeal, 12 days delay. And, my lord, that is
When the application for restoration was filed.
the restoration has been filed, my lord, 2014, my lord. 2014, 19. Yes, my lord. Yes, yes, my lord. I have stated the reason, my lord, that it was, my lord, noticed to us, my lord, and the learned lawyer was, my lord, due to it.
Long time it is not possible. So you'll have to effect service afresh. Please effect service afresh.
Huh? Yes, yes.
The application for condonation of delay was dismissed for default on March 11, 2010 by
The appeal was dismissed in 2015. The restoration application has been filed on
For the
2024.
petitioner, my lord, Mukundalal Sarkar.
So we have directed both to him also and to the.
No, my next matter, nine.
Oh, next.
Yes,
Who
madam.
is appearing?
Mukundalal Sarkar is appearing for the petitioner, my lord. He is due to his personal difficulty, my lord. He has not come to court, my lord.
This 2000
Proceed with the execution.
the execution, my lord. This is divorce degree. My lord, divorce has been granted, but so far as my lord, 125 is concerned, and order was passed by this honorable court to pay the amount. My lord, in 125, divisional application was made. It was directed to be paid, my lord, to the wife 7,500 and to the child 7,500.
How much?
Total 15,000. My lord, since 2022, my lord, the husband is not paying anything. Now, my lord, the original who has, my lord, now, my lord, the original, the application who has filed this application, learned advocate. My lord, no.
You have not married again.
No. No, my lord, although, my lord, the
age of your child.
my lord, age, my lord, he is a student my lord, reading in college. My lord, the original learned advocate who was there, my lord.
State appeal. So what can be done?
Well,
State appeal as of now.
That's true, but my lord, every occasion when this application is coming, my lord, they are taking time. My lord, initially, the brief.
Imposing cost for adjournment. Where is Mr. Sharma?
My lord, he involved.
Produce the doctor certificate. Tell him to produce.
Well, allegation has been made against the learned advocate.
Next day, you'll.
Allegation has been made against the learned advocate. The petitioner make an allegation against.
What is the name?
My lord, his name is, my lord, Imtiaz Aslam Lodhi. I mean, in one paragraph, he admitted that he was aware about the dismissal. That is true to his knowledge. Then my lord says something else.
My lord, kindly one day accommodation, my lord.
Shows that he is not interested. He just wanted this matter to remain to matrimonial suit dismissed on the ground that he could not prove cruelty.
Yes.
Oh my God! It was dismissed earlier, also restored.
Yes.
Then the conduct is very bad.
I am not.
Just for him, that he must convey that the
Yes.
conduct is very bad. Take a step somewhere else if they have not paid 125.
My difficulty is, madam, nothing is pending there so that I can pay per stay. This is, madam, the suit has been. So, madam, I have to, madam, execution. Madam, each time I have to, madam, approach the executing court in order to get the money.
Not today, anyhow. I'm keeping it.
Get from
The last chance. Let him. Tell him to produce the medical certificate.
I am applying for the appealing, my lord. My lord, last week, my lord, I have been served with a copy. Is to service commissioners. I have received Affidavit in opposition, copy of affidavit.
What,
Kindly
what is
give 1 week time, my lord.
position has been filed?
I know, may I file it? There was a direction. I have served the copy on the 14th of January.
Yes, ma'am.
My learned friend is praying for some time to give the reply.
January, now we are on 22nd of January. You could have prepared, because 1 week time was also given to you. You could have prepared the reply, sir. You do not want your matter to be disposed of. Disability status,
Yes, my lord.
disability. What, you wanted,
Well, he was initially recommended, but after which on checking, it was found that he was not eligible to be considered.
medically
Yes, so it was withdrawn, his recommendation. After that, there was a direction for him to appear before the appellate board. He did not go in spite of being called 3 times.
My lord, kindly
So the writ court in the second round of litigation
reply.
dismissed the writ petition, as he was not attending in spite of.
what the litigation.
Yes, my lord.
My lord.
The opposition filed by the respondent number 4 and 5, we taken on record. The counsel for the appellant submits that the copy of the opposition is served upon him recently, and and therefore he should be permitted to file reply. So, time to file affidavit in reply is extended by a week from date. This is the matter recording.
Deeply obliged.
For the next.
And I'm for the commission. My lord, state this application is for appropriate order, my lord. Where, my lord,
Appropriate order.
my lord, here, my lord, what happens? My lord, the petitioner before.
Not know from where this concept has originated. Appropriate order. Didn't even say that I wanted an application for stay, I wanted an application for injunction, I wanted an expeditious disposal of the matter. Appropriate order, what is this? There's no categorization in our system.
Miscellaneous, we say it as a miscellaneous application. But here he prayed for, my lord, he appeared in the 12th.
Benefit of the appointment.
Yes.
From 13.
Lordship. The 12th RLST, the regional level selection test, is appeared. So, my lord, he was declared to be unsuccessful.
How can it be granted at the interlocutory stage?
My lord,
How can it be? That means allowing the appeal itself.
that I will not pray before your lordship. Only one.
Better let them.
Only one. My lord, I can do that, my lord, but if very, very little, my lord, is. I just wanted to submit.
We will not dispose of any appeal now.
But
We will dispose of the appeal. We are taking up application.
But as your lordship pleases, but here only the very small point is involved.
The
No, no, my lord, I just wanted to point it out.
Very small point is that. Yes.
Great.
70, my lord.
After 3 days.
70 for the appellant.
What is this application?
Well, I have sought the notice to the state as well as the for defect.
Out of time. Section 5 is fine, no stay. 33 days.
Then I have to text him.
The report of the additional staff reporter indicated in the for the next.
71, my lord. I am for
The service.
I'm for the appellate.
I am for the secretary board, your lordship.
This matter, my lord. Yes. My lord, this application relates to, my lord, after change of determination, my lord, the single judge passed the order.
Can one is withdrawn?
Can one is withdrawn regarding, my lord, section 5 application that was, my lord,
Then what is can 3?
can 3 is the, my lord, section 5 application. My lord, that was, your lordship gave me liberty to file a fresh. Because date was not mentioned during that time. So I have served it.
31 days.
Yes, my lord.
What about the say?
Well, the claim over here, your lordship, the learned Singh.
What is it?
Oh, delay. First letter. Well, Section 5 application has been taught not to raise objection, your lordship.
This is an application seeking for condemnation of delay in preparing this instant appeal. Stop paragraph. As it appears from the report subject like that there is a delay of 33 days preparing this instant appeal. 33 was the delay preparing instant appeal. It counts as assigned in this paper.
After, Lord? Yes, pardon me. Lord.
Yes.
Yes.
No, 72. Doctor state for the state. Accusing petition. Lordship, I am for the state lordship.
Sorry.
It is appellant to me.
My lord, 73, I am appearing for the respondents, my lord.
3 minutes restoration application. Yes. Is how much days delay?
My lord, the restoration application is out of time, my lord, delay of 20 days.
Yes.
No separate application has been preferred, my lord.
Is it necessary, sir? In
My
view
lord,
of the latest Supreme Court judgment, is it necessary? Composite application can come. So, is it necessary to file a separate application?
no, my lord, as per the Supreme Court latest judgment, my lord, that is not required, my lord.
That is not required. Then 20 days. Yes. This is an
It is an application for restoration of the present appeal, which was dismissed for default on
28.
That the extent application is filed by
March 27.
Date of dismissal 28 March.
2023, we know.
Causing delay of
28
days.
21 days.
The applicants are prevented by sufficient reasons from not preferring this restoration application within the stipulated period of time as provided in
Grateful, my lord.
The appellant is directed to prepare 8 copies of informal paper book, cyclostyle, typed, Xerox, whatever, within 4 weeks from the date of the
Already arrived.
record has
LCR,
arrived.
LCR arrived.
Within 4 weeks from date. Stop.
6 weeks.
No,
First appeal.
4 weeks from date. All formalities, including the filing of the appellant declaration in preparation of the paper book, are dispensed with. Immediately upon filing the paper book, the department shall cause the service thereof upon the respective councils.
Well, I do not know whether he is appearing for all the respondents. Whether they notice
Whatever.
My lord, I am appearing for all the respondents. 2 respondents, I am appearing.
Let the appeal be listed after 6 weeks.
Grateful, my lord, grateful.
But this is my application for substitution.
Up to 2015. Service.
Yes, I have served every
received?
service. But as out of 14 respondents, 7, 8, 9, 10, and 11 has come back with the remark that insufficient survey address.
Yes.
All the others have received.
Matter is pending in any other court, trial court or
Well,
something?
this is from a partition suit. It has come.
Preliminary decree or
Preliminary decree has been passed.
So the matter is pending.
Yes.
All the 14 respondents are represented.
No, they are not. Yes, but they are not appearing. Only 2 are appearing now in the before the trial court.
Somebody must have engaged the lawyer or
yes, they have engaged a lawyer. 13
What is the substitution application?
My lord, the appellant has died. He was the sole.
Have
he
you
was.
served the copy?
Yes, my lord. Copies have been served so far as. My lord, the others are concerned. I have served. 1, 2, 3, 4, 5, 6, 14.
Contesting defendants have been served.
My lord, other than those 5.
Oh, are they a contesting defendant?
Yes, my lord. 6 is the contesting defendant who has been served. 13 is the contesting defendant who has been served.
Who have been served?
Yes, ma'am. 14 main opposition is from now 6 and 14. They both of them have received this copy. But the appellant died on 19th of November.
The affidavit of service filed today revealed that
Substitution, my lord.
Within time or out of?
Out of time, my lord. Out of time,
Serve the
only,
copy.
no, my lord, the copy is not,
Serve.
my lord,
Service returnable after 2 weeks.
my lord.
Anybody is appearing in the trial court.
Yes, my lord. One advocate is presented, my lord, in a
What
trial.
is the nature of the suit?
My lord, it's a suit for declaration, permanent injunction, for receiver, my lord, and accounts.
Matter is pending.
Yes, my lord.
Execution for what?
My lord, I do not have that instruction, my lord.
Then you serve the rest.
My lord.
Next.
मैं 76 मतलब I am for the respondent DPSC Puro Midnapur. But Mr. Maiti, Sakko Maiti appearing on behalf of the appellant.
Where is he? Dismiss?
No. Next week as your lords.
Not this week.
Yes. Dismissal will not help. That floor.
77 is a restoration application. 77. It's a restoration application. I have filed within the time.
Service? Service?
FEB service has not been completed, Lordship. But I have served.
Yes.
Serve the other side.
Lordship, I have served.
Commission, we have received it.
And served through the email, Lordship.
What about school?
School I have served through email, Lordship. I have called before prior
Then
to advocate.
affidavit of service have to be done.
Lordship, next
This
day.
cannot be done without that. Not today. Prepare affidavit of service.
My lord,
Kindly make it not this week.
just
Not this week.
I would beg to submit just one thing, my lord. In the restoration application, in the prayer section, my lords, the names of your both my lords have been wrongly written. Yes, my lord. So kindly direction be passed on them.
On prayer part?
The prayer part.
No, Lordship, let me check, Lordship. No, Lordship, this is the prayer part. So mat 1, 2, 3, 8, Lordship. This is a mat 1, 2, 3.
Of the judge.
Dr. Subhajit. Honorable Justice Haristan and Honorable Justice Poshanjit Bishas, Lordship.
Spelling.
Sanjeev Bishas. What is it?
Just check the spelling.
You can check the email.
No, just check the spelling of Honorable Justice Harish Tandon.
Yeah. But this minor X, let me check, Lordship.
A typographical error in the name of the Lordship.
That's only O instead of A, Lordship. That's
What?
Lordship, there is only O, Tandon, T-A-N, the typical mistake, Lordship. T-A-N-D-A-N, and here is a T-A-N-D-A-N instead of O, Lordship.
Leave is granted to the counsel for the appellant to amend the prayer portion here and now. Let this matter be listed in the next week to enable the learned advocate for the appellant to file the service. To correct it here and now.
Grateful, my lord.
Call the next.
78, my lord, I am for the petitioner, my lord. My lord, 78, I am for the petitioner, my lord. 78, I am for the petitioner. My lord, matter regarding dismissal from service, my lord, but during pendency of this appeal, he has been reinstated in service, my lord.
So you do not want to proceed?
Yes, my lord. Only thing, his due salary direction.
Either you come or say what you want to do, or
my lord, he has been reinstated in his service. He has joined on 9th March.
Sir, would you like to do the case? Then do the case.
No, my lord, he has already reinstated. Lordship, not audible, your lordship. Lordship. Lordship is not audible to me, your lordship.
Where is the surveys of applications upon the respondents?
My lord, service is not completed, my lord, because he is already
Sorry.
reinstated in his service, my lord. So I have nothing to.
Nothing to do, then don't proceed with the appeal. If you want to proceed with the appeal, then we'll have to serve.
No, my lord, he has joined his service.
So would you like to proceed with the appeal
My
or
lord,
not?
only thing,
You want
only
here joint
liberty.
service. We are not going to whether you is entitled to a any kind of a salary for the past period or not. We are not entering. If you want to press upon it, then we'll have to serve.
Yes, then my lord, I will not further proceed with, since he has reinstated in his service.
So, say
Yes,
with
yes.
record, the counsel for the appellant submits that despite the disposition
Appellant, my lord. This is with respect to one of the appointment of the headmasters. Earlier occasion,
what
my
is
lord,
this can to
but, I'll be just
what
visiting
is
a
this can to
but, unnecessary orders, my lord.
unnecessary?
So, my lord, I will just only use a reply to the affidavit which is used by Melanus Senior. It is already ready but could not affirm because of the, my lord, the learned advocate on records.
Opposition is filed.
It is affidavit to pursuant to your lordship's earlier direction.
Oh.
But I'll just use an exception to this, which is ready but could not affirm because of the difficulty
counsel
of
for the appellant submit that
advance copy.
an affidavit taking exception to the affidavit filed by the Central School Service Commission So what? Advance copy will do.
I've just had it.
Likhi dao. Okay, an advance copy of the said affidavit taking exception.
Have your lordship's kind, I have a prayer that Mr. Kullan Bandyopadhyay is leading in this matter, my lord. If your lordship kindly take it up on Friday, because he'll be available on 24th, as he has told me.
This bench may not be available on 24th.
But kindly, my lord. 1 day's accommodation only.
May not be available on 24th.
Kindly, one day accommodation. 1 day. On Friday, my lord.
Can't assure
Then
on
my
Friday.
Monday, my lord.
That also we can't assure.
For whom appearing?
I'm appealing for the appellant, my lord.
Not today.
Lordship.
Yes.
Ready to, I'm calling for accommodation for this week, my lord. Can you take it Monday, my lord?
Not this week.
My lord, I'm for the appellant. My lord,
What are these two applications? Can
I am for the
one-
state respondent led by Mr. Shuman. Your lordship, the application can one is for limitation. Previously, my lord,
Limitation means?
Delay. My lord.
Condonation.
Condonation.
Limitation.
Yes. Condonation of delay.
Have you served?
Yes.
How many days delay?
15 days, my lord, subject to correction.
Have you used your affidavit?
No, my lord.
Why? There was a direction for
School already given the affidavit, but at point has already decided by your lordship.
no point for condonation or delay decided by us. So condonation,
Yes.
you pass the hurdle.
Yes.
Cross it.
Yes.
Yes.
First, my lord, condone the delay.
There was already a direction.
My lord, kindly grant me some time.
What?
my lord.
There was direction
For
as
admission.
far back as in the month of February 2024. Virtually a year has passed. You are for whom?
For the state respondent, my
So,
lord, for the DI.
Mr. Suman Ghosh and Mr.
Shanko Prasad.
Rai, you appeared
Yes, my lord.
and there was a direction. Respondents are directed to file their affidavit in opposition within 3 weeks. Did not.
In
Will not
respect of main application, my lord, main matter they have given. They have given that so far, my lord, this order perhaps, my lord, it is our fault to bring that there is an section 5 application.
No, can 1, can 2, both. The order is passed.
Yes. But my lord, section 5 is, my lord,
So they chose not to oppose section 5. That means.
Yes. In main application, school already given the opposition.
We have given the opposition. So opposition, they do not want to contest the condemnation.
Section
That shows that.
There's an application seeking for continuation of delay in